question, public interest litigation at 2 p.m. before your lordships. This is in regard to Raiganj incident. But the
Already single bench has been there dealing with the matter.
No, this is not that one, my lord. This is the other person, the Mithujoy Bowman, who
Monday we'll take it up. Please file it today.
My lord,
was, the
may I,
entire situation is out of the great, my lord.
Monday,
Kindly, let us move it today, your lordships.
Monday, please.
Lordship, I am praying before Lordship to file this, to grant me leave for filing this
What is the urgency?
review application that's which is coming came before your Lordship thrice. After Supreme Court order, I want to file this Lordship review application. It was passed on 4th of April. Lordship, without certified copy. Kindly grant me leave.
No, what is the Supreme
Lordship,
Court?
kindly say.
What is the Supreme Court order?
Lordship, that review application, Lordship. Which came thrice before your Lordship. That matter. With SLP, it was filed, Lordship, the certified copy. That's why I'm not.
SLP, you have filed the
Lordship,
certificate. Then you can seek for dispensing with the
Lordship, I have been allowed to file this review application.
Already.
Lordship.
may I pray for my lord's leave to file an appeal
Grateful,
without
Lord.
certified copy, my
What's the
lord?
urgency?
My lord, urgency is, my lord, by the order impugned, my lord. My lord, an order of the chief electrical engineer, whereby it has held that my home lift doesn't require any permission, has been set aside, and my lift has been directed to be demolished, my lord, as expeditiously as possible, my lord.
My lord, may I permitted to mention one mandamus appeal? It was running in the list, but it is expected to be listed on 25th of January 2013. The matter has not yet been listed. I have just got the annex copy of it.
Which year is that appeal?
It is in the year 2022.
22. Let us see what's the position.
May I permit to mention one matter in which I got a compensation order from the trial court that was appealed by the Axis Bank. Let the matter appear in the list.
You give a mentioning slip.
Yes, I'm giving.
Now you give it.
I'm praying for my lord, inclusion of this matter into my lord's list. This is a 2016 matter. My lord, the private respondent illegally filled up the pond, and that's why I filed a writ application. And earlier occasion that was moved, and I obtained stay. But despite of that fact, my lord, they are now they again started to fill up the pond.
Then you file a contempt. We list the contempt immediately. You file a contempt.
But that matter is pending, my lord. I'm praying for hearing of this matter.
No. That if you are saying that it's a violation of an interim order, you file a contempt. Then on that date, the matter will come up.
Obliged to my lord.
It's already there, running in the monthly list.
My lord, leave may be granted, my lord, to file an
What's the
appeal.
urgency?
My lord, actually, my lord, the Mela was supposed to held on 25th, but my lord, the authority, my lord, they have restricted some rights. That's why, my lord, it's.
There's no urgency. You file it with certificate copy. Please call the list.
Appellate side, daily list, item number 1.
Yes.
Please, in this matter, your lordship, the client could not come to file the stay application, your lordship. I'm praying for adjournment for a week.
No, it won't be adjourned. It will be adjourned by 3 months.
Lordship, don't, please, your lordship.
Then why did you move the matter?
Came automatically in the list, your lordship. It came automatically in the list. Lordship, subject to your lordship's correction.
Now your rebate application was beyond 1 year.
Lordship, it is beyond 1 year because of the fact, your lordship, I have to get an endorsement for export from the Export Customs Authority. That I got in the year 2013. Then only if I had filed it within that period of time, because I did not get the endorsement from the Customs Authority. So it will be infractuous, Your Lordship. I am covered by some of the judgments of the trust.
No, this is the matter you wanted inclusion in the list. No? You had mentioned this matter.
No, I did not mention. Subject to Your Lordship's correction. It
No,
came
no.
automatically. I think so. There is a mentioning, then
No, matter was supposed to be listed on 18th of January 23. And why have you not filed the stay application?
Lordship, he could not come, Your Lordship, on that
Pardon?
time. He could not come at that time, Your Lordship. This. So give me.
Learned advocate appearing for the appellant submitted that requested time for filing stay application. Adjourn the matter. The matter stand adjourned by 6 weeks. Next,
Item number 2.
May it please Your Lordship, I am for the petition. In this matter, I am for the petition.
We are for the state respondents in the matter.
Lordship, in this matter, Your Lordship, regarding the way bill, Your Lordship, expiry of way bill. On 7th of May, I was supposed to carry my goods from Calcutta to Durgapur. Durgapur Industrial Zone. On 7th of Lordship.
the scope of the appeal. First, what is the interim order you sought for? The learned judge says there is no scope for passing an interim order. You first convince us that what is the interim order you sought for? What is the prima facie case you have got?
Lordship, the prima facie case I have got, Your Lordship.
Let us see the prayer in the writ petition.
It is at page 114 of the stay application, my lord.
Stay of the appeal order, Your Lordship. They have imposed penalty. Penalty has been imposed, Your Lordship.
Where is that impugned order? 26 September 2022.
It's in the appeal, Your Lordship.
Page.
It is at page 67 of the stay application. my lord.
Page 66.
It's an elaborate order. It runs up to page 88. Sure. Sign number item is different. Pin number item. नहीं ते पृष्ठा गवर्नमेंट बोले तो आई थिंक
Now it entered Durgapur before the expiry of.
It entered the Durgapur Industrial Belt, Your Lordship. It was a Sunday. I was carrying the goods to Larsen and Toubro. And Sunday, there was nobody to take it. They told me from Panagar is also within Durgapur Industrial Belt to go to Durgapur itself. This Asansol Durgapur Industrial Belt I entered within the period of time.
No.
Your Lordship, you have missed there is a delay of 8 hours delay straight away. And second, they weighed the goods. And there was a difference in 0.1% difference in the weight. I'm asking myself, if I weigh in 2 weigh machines, just now it will be different. There will be some difference will emerge.
What was the goods which was being carried in the vehicle?
Goods being carried, Your Lordship, the machineries, some machineries, 30 tons. plates, some plates being carried, steel plates for Larsen and Toubro.
Where is the finding of the appellate authority, sir? He's writing some 22-page order.
There is no finding regarding the variance and other things.
No, that mens rea, whereas he discussed.
Mens rea has not been discussed. At page,
Come back.
Sir, what sort of an order is this, sir? He's extracting it thrice. He has extracted the same thing. The Karnataka judgment.
The mens rea factor, my lord, he has dealt in page 87, my lord, subject to your lordship's kind sanction, my lord. Page 87. Shriram judgment has been quoted below.
So up to 12 p.m. midnight, the e-way bill was valid.
11:59.
And it had, according to the appellant, it had entered into the Durgapur industrial area within the time permitted.
No, the vehicle was to be delivered, the goods were to be delivered at Panagar. And it was intercepted at Durgapur.
Panagar is also within the industrial belt. Your lordship can take
Panagar
take judicial notice.
Yes, it was a Sunday, and the consignor or consignee, whoever it is, they gave loading instruction bit late. Therefore, the vehicle was awaiting drivers.
But only, my lord, vis-a-vis the judgment relied upon by the appellate authority, that Shriram Mutual Fund, my lord. Only that, my lord, there has been a violation of section 68 read with rule 138(1) of the GST rules, my lord, where it has been stated.
GST.
My lord.
But every violation you impose 200% penalty.
According to section 129 of the Act, my lord, if your lordship kindly turns to rule 138, my lord.
One second. What is section 129?
Section 129 is the penal provision, my lord. Section 129. Your lordship got that, my lord? 129.
Oh, 129 is the power given for detention and seizure
And imposition of penalty, my lord.
yes.
Equal to 200%. Lordship has seen that amendment, my lord, in terms of the Finance Act 2021. On payment of penalty equal to 200% of the tax payable on such goods, and in case of exempted goods, on payment of equal to 2% of the value of goods, or 25,000 rupees, whichever is less.
Now, what is the rule you are referring to?
My lord, rule 138. Rule 138. Under rule 138(10), my lord. Your lordship will find a table.
Taxable goods or not taxable goods are into infraction is different. Infraction is a question, not the taxability.
जजमेंट ही बोला
This provides for the validity period
Validity
and
period.
extension.
An extension has to be made within 8 hours. my lord,
8 hours, 8
within
hours.
8 hours.
Now, let us see the finding of it. Forget about the judgments which he has quoted.
Hello.
Page 85. Vehicle was intercepted properly as per the provisions. Validity of the e-waybill expired after 11:59 p.m. on 8/5. Only after the expiry of the waybill. Now the appellant submitted the vehicle reached Durgapur within the validity, but could not produce proof.
In favor of his submission.
So it was 20 kilometers.
20 kilometers away.
20 kilometers.
Within the industrial belt also. I'm just can take judicial notice of this fact.
No, where have you said within the judicial belt?
That I'm submitting, your lordship. That is
Industrial belt.
industrial belt itself.
Ah.
Panagar.
In your submission, where have you said that?
Submission, this point, this is within the industrial belt that I'm submitting, your lordship, this. That everybody is aware, your lordship, of this fact, subject to your lordship's correction. That it is within that belt itself.
On what date the vehicle was intercepted? On 9.
On 9 at 9:35 a.m.
Where was the vehicle at that time?
At Durgapur, industrial area itself. Of the going to the factory of
Where is the e-way bill?
page 17. This is your lordship to see.
70.
17. 17 of the stay petition, e-way bill.
It says ship to so and so, Panagraga,
Panagar.
Durgapur, Bardhaman, West Bengal.
Ship to Panagar.
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 It
And
was
where was the vehicle when it was?
at
Durgapur.
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 Not at
20
Panagar.
kilometers away.
Panagra is a, what is it? It's a municipality, is it?
It's a municipality. It's a from Asansol to Panagar to Bardhaman. There is a totally an industrial area.
And it also says Durgapur.
Durgapur. And Durgapur itself.
Well, the vehicle was intercepted at Durgapur.
Durgapur.
It was destined to go to Panagar.
Panagar.
And it was around 20 kilometers away from the destined place, my lord. And my lord.
But if you see page 17, it says ship to Kankora near Shantiniketan Road, Tirlok Chandrapur, Badbad, Panagra, Durgapur, Bardhaman.
Bardhaman, yes.
Bardhaman.
This is Durgapur.
It was to be shipped to Panagar. Durgapur, my lord, is the.
No, let us say this is the what is it? The main building or heritage building.
This is within Calcutta.
And this is courtroom number 1.
Courtroom number 1.
So if he has come into the building and you say that it should have been brought to courtroom number 1, what does it make?
It was around 20 kilometers away. Ashok, may kindly appreciate
But still it is within Durgapur.
that. Durgapur, my lord, it was, but it was, my lord, on the other side.
Durgapur is the subdivision.
And where is the original authority's order?
Lordship, this order. Page 42. This is your
Imposing penalty.
penalty, your lordship.
The reason order is at page 44.
44. Starts at page 44, your lordship, this.
Page 47. I mean, on that page only. Sorry,
But he produced one email communication from the consignee.
Consignee, your lordship.
That is, and attached a copy saying that we gave a direction to unload the goods at a different place.
Please.
So the bona fides can be seen. And it is a multinational or a blue chip company.
But only in that case, my lord, we are placing reliance upon that judgment of Shriram, my lord. My lord, that mens rea in a revenue, my lord, revenue matter, there is a civil obligation, my lord.
No, but then
Not-
in all cases, you can't impose 200% penalty.
That is in terms of section 129.
And what is the penalty amount? 4 lakhs 32,000.
8 lakhs.
My goodness.
তো টাকা দিয়ে দিয়েছে তো ওটা 8 lakhs কোথায় কোথায় পাচ্ছ 8 lakhs It's not 8 lakhs.
The total invoice amount is 28 lakhs.
28 lakhs.
Out of which 8 lakhs is penalty.
Penalty. Lordship is subject to a correction for minor infraction under section 122. I am liable to be punished, penalized or something. Section 122. 10,000.
Section 122.
10,000.
10,000. They'll be liable to pay 10,000.
Under which clause you will bring this this offense?
Lordship, under the, just I'm submitting your lordship, clause number, transport any taxable goods.
Clause
without
number.
cover of documents as may be specified.
14.
X14.
14.
X14.
Yes.
Transport any taxable goods without the cover of the documents as may be specified.
Or an amount equivalent to the tax.
And the penalty is 10,000.
10,000.
10,000, your lordship.
But in this case, my lord, it is not relatable to section 129. My lord, in this case, the relevant section is section 68, inspection of goods in movement.
But it is not, it will not fall under clause A and B. Clause A is relating to claim for input tax credit. Clause B is escapement of payment of
Your
tax.
lordship is referring to
So sorry.
section 68, my lord. Section 68, my lord, read with rule 138. And it attracts, my lord, when there is a violation, section 129.
Lordship, this is equally applicable. Section 122 is equally applicable, Your Lordship. There is nothing to say here that there.
But the facts are very. Where is that Karnataka judgment?
Karnataka judgment copy আছে
Lordship, I am relying upon your Lordship's judgment. And Ashok Sureka, Lordship's judgment.
Ashok Sureka is in dispute.
No, should you not see whether there is an intent to evade payment of tax? The only in the e-way bill, the address includes Durgapur. And on 9:35 a.m. it was.
The address includes Durgapur, but it is not destined for Durgapur. Durgapur is the subdivision, my lord. And the district is Bardhaman. It was destined for Panagar. The goods were to go to Panagar.
Panagar
The
is
goods were, my lord, it is like, my lord, I'll tell you, lordship. It is like a place called, there is one specific place called Durgapur, and there is one specific, my lord,
area called
this subdivision called Durgapur. In Durgapur, my lord, there is one place called Panagar. The vehicle was intercepted at Durgapur. There is a specific place, though it was destined for Panagar. And this e-way bill which mentions the Panagar area, the subdivision, it is Durgapur, the subdivision. So it is like that. It is like that, my lord. Vatican City, when I say, my lord, Vatican City includes the country as well as the Vatican City.
So Panagra will fall within the subdivision of Durgapur.
Lordship, it is in the outskirts of Durgapur. If you leave the expressway, there it is the outskirts of Durgapur. If it is caught in Behala or some other place in Jadavpur area in South Calcutta, it cannot be said it is not Calcutta. This is
my lord, I'm grateful to my learned friend. If a good is intercepted, say for my lord, Salt Lake area, well, it is Salt Lake. But my lord, when I'm saying that it has to be Rajdanga main road, it has, well, the place is something else, but all falls within Salt Lake. Right? Salt Lake, Kolkata 91.
Lordship, I am also covered by your Lordship's judgment also. Ashok Sureka's judgment.
They are referring to Sriram Mutual Fund.
Sriram Mutual Fund. Lordship is
saying that intention of the party is irrelevant.
That was.
But how to ignore that?
Also. Sriram Mutual Fund GST related. Which one? Sriram Mutual Fund.
Though I have copies of Sriram Mutual Fund for another case, Lordship, I can refer to. Lordship may kindly turns to paragraph 29. Paragraph 29.
This is under a different enactment.
Under SEBI. But if your Lordship kindly says, my lord,
under
the ratio laid down by the Honorable Supreme Court in paragraph 29, my lord. Lord, may I place it before the relevant parts, my lord? After in between placetum B and placetum C at page 11.
In our opinion.
In our view, the penalty is attracted as soon as contravention of the statutory obligations as contemplated by the Act is established. And therefore, the intention of the parties committing such violation becomes immaterial. In other words, the breach of a civil obligation which attracts penalty under the provisions of an Act would immediately attract the levy of penalty, irrespective of the fact whether the contravention was made by the defaulter with any guilty intention or not. This apart, unless the language of the statute indicates the need to establish the element of mens rea, it is generally sufficient to prove that a default in complying with the statute has occurred. Thereafter, my lord, the clauses of the SEBI's Act. Thereafter, your Lordship kindly turns to paragraph 33, my lord, of the same judgment. Paragraph 33 is at page 372, mens rea. Whether has your Lordship got that, my lord? At the bottom, whether an essential element for imposing penalty for breach of civil obligations. This court in a catena of decision has held that mens rea is not an essential element for imposing penalty for breach of civil obligations. Several judgments have been quoted, my lord, up to page 16, my lord. Thereafter, my paragraph 35. In our considered opinion, my lord, the page 16, penalty is attracted as soon as the contravention of the statutory obligation as contemplated by the Act and the regulation established. Hence, the intention of the parties committing such violation becomes wholly irrelevant. A breach of civil obligation which attracts penalty in the nature of fine under the provisions of the Act
খুবই ভালো। Supreme Court also, huh?
Lordship, I'm relying upon a Supreme Court judgment also, Supreme Court order, relying only 1 day's delay, 1 day's delay. Mine is a better case. And they are also 22. আমার কাছে কপি আছে।
আর সারাবদার কাছে কপি আছে, সারাব কপি দিই
না না কপি পরে পরে
আপনার মাইকের জন্য রেখেছি তো
আরেকটা কপি দিয়ে একটা দিয়ে দাও গুরু, এখন নেই আমার কাছে,
আছে,
আপনার কাছে নেই। This is very unfair on your part.
সারাবদা
Lordship, page number 1, beseech your Lordship, page number 1 to 4. This is a judgment. Had expired day earlier. And there was no menstrual.
Total আলাদা facts ওখানে বাড়িতে রেখে দাও।
This is altogether different fact in Satyam Shivam papers, my lord. My learned friend is lying upon, subject to correction, my learned friend. Lord, here the officer has kept the vehicle in his home. Lord, the officer concerned was reprimanded and subject to correction. Departmental proceeding was directed to be initiated against him.
For 13 days.
For 13 days, he had kept the vehicle in his home.
But whether the intention to evade payment of tax, should it not be established?
But there is violation of section 68. I leave it to your lordship. Read with rule 138, which automatically attracts section 129.
And lordships also judgment of your lordship also, page Ashok Kumar Sureka.
Ashok is on altogether different. Two EWA bills better.
They have generated, but
Lately, they had generated the second EWA bill.
No. In terms of rule 138, he has to have a e-way bill.
EWA bill.
And that validity of the e-way bill is also mentioned. And the proviso also provides for extension of time. That is there. Now, what is the other rule you are referring?
My lord, I was referring to section 68, read with rule 138, specifically sub rule 10, and which attracts section 129 for imposition of penalty.
Lordship
For
has given the ratio also.
Offense is under section 138, read with rule 138 and 129 is penalty, penal provision.
Only thing is,
Lordship,
why they are an accept and contraventions of the provisions of this act of it's made that. So whether there was a contravention, we need to decide. Rule right to possess. So he gives an explanation. I am not confident that I will get the jurisdiction area within the time permitted. So we should not actually.
declaration it is
So your maximum would be 35. Sir, the e-way bill expired at 12 midnight.
11:59 PM.
He has got 8 hours time to extend. So if you give them that credit, It will be 1 hour 35 minutes.
1 hour
delay.
35.
1 hour 35.
35 minutes.
So there has been violation, my lord, but with regard to quantum of penalty, my lord, I leave it to your lordship. Being an officer of this court, my lord, I leave it to your lordship. But there has been violation of the
28
statutory provision.
28 lakhs were the goods invoice value is 28 lakhs and odd. 8 lakhs is penalty means what?
I leave it.
Lordship, I'm relying upon your judgment, your lordship, 7 and 8. Is Sureka, it lays down the ratio also. If there is no intention, page 7, your lordship, of the compilation, paragraph 7 and 8. If there is no violation,
It is altogether different, my lord, on a different footing. There were two
breakdown of vehicle,
way
same
same
vehicle.
bills. And my lord, with deepest of humility, my lord, and now this by placing reliance upon this Shriram Mutual Fund, my lord, judgment, the mens rea is not an essential ingredient. with regard
The enactments which were examined by the court
This is not
was totally different.
different.
And the various other judgments which are referred, they are all under penal statutes, FERA, etc.
My lord.
Guljak is a VAT.
Guljak is of VAT, my lord, subject to correction.
Lordship, this is
Guljak is a VAT.
VAT.
based of my subject to your correction, Gujarat VAT Act.
Ah.
This Shriram Mutual. I
No,
have not.
SEBI.
Huh?
SEBI.
SEBI Act. This is not.
The VAT Act for that.
GST Act.
Guljak judgment is of
This
Gujarat.
intra-court plea by the writ petitioner
Huh?
is directed against an order stated February 2023 in WPA 1786 of 2023. By the said order, the learned writ court declined to grant any interim order, though was inclined to entertain the writ petition and call for affidavits. The appellant, being aggrieved by such order, has filed the present appeal. With the consent of the learned counsels appearing on either side, the writ petition is taken up along with this appeal. The short issue involved in this writ petition involved in the case is whether 200% penalty could have been imposed in terms of section 129 of the WB GST Act.
GST. 170.
The petitioner, the appellant, was carrying goods which were consigned to Lawson and Tubor Limited in West Bengal. The e-way bill generated on
7th May.
7th May 2022 at 3:46 p.m. was valid up to 8th May 2022, 11:59 p.m. The goods were shipped to the following address. So page 17, this box. Sorry, for entire thing. It is not in dispute that the vehicle along with the goods entered the Durgapur industrial belt within the validity of the e-way bill. The vehicle was intercepted on 9/5/2022 at 9:35 a.m. at Durgapur, and the vehicle was detained along with the goods on the ground that the e-way bill had expired on 8/5/2022 at 11:59 p.m. The explanation given by the appellant was that it was a Sunday and the consignee had given instructions to unload the goods at a different location within the same area. And in this regard, the appellant had produced a email sent by the consignee stating that they had given instructions subsequently to unload the goods at a different location within the area to which the goods were consigned as per the e-way bill. The original authority did not accept the explanation given by the appellant and imposed 200% penalty. An appeal was preferred against the said order to the Senior Joint Commissioner, State Tax, Chaurangi Circle, who by order dated where do you get the date of the order?
Order dated 22/8/2022.
20 by order dated 20. No. Where do you get the date?
Lordship, I get the date at page number 67, your Lordship.
67.
Date of appeal, date of issuance, or date of appeal,
Date of the order.
date of order 26th
Date of
of
order,
September 2022.
Dated 26 September 2022, affirmed the order of penalty imposed by the original authority and dismissed the appeal petition. Agreed by the same, the appellant filed the writ petition. We need not go into the various judgments which were referred to by the learned advocate for the appellant and the learned advocate for the state, as we are convinced that on facts, there was no intention on the part of the appellant to evade payment of tax. In any event, in terms of Rule 138 of the WBCGST rules, the GST rules, if a e-way bill had expired, the transporter had 8 hours time to seek for extension of the time stipulated in the e-way bill. If that allowance is given, the at the time of the goods, at the time of the vehicle along with the goods was intercepted, it was delayed by about 1 hour 35 minutes. The address details given in the e-way bill will show that the area Durgapur has also been mentioned. Admittedly, no, not admittedly. It is not disputed that the vehicle was within the Durgapur industrial belt, though not at Panagraha. Thus, considering the peculiar facts and circumstances of the case, and in the absence of any material produced by the revenue to doubt the bona fides of the appellant, we are of the view that penalty could not have been imposed in this case. The learned advocate appearing for the respondent state had referred to the decision of the Hon'ble Supreme Court in Chairman SEBI versus Shriram Mutual Fund 2006 5 SCC 361 for the proposition that the intention of the party committing such violation becomes immaterial when there is a contravention of the statutory obligation. Section 129 of the WBCGST Act deals with detention, seizure and release of goods and conveyances in transit. Subsection 1 of section 129 states that notwithstanding anything contained in the Act, where any person transports any goods or stores any goods while they are in transit, in contravention of the provisions of the Act or the rules made thereunder, all such goods and conveyance used as a means of transport for carrying the said goods and documents relating to such goods and conveyance shall be liable to detention or seizure, and after detention or seizure shall be released upon payment of penalty as mentioned in the clauses under subsection 1 of section 129. Therefore, what is required to be considered in every case is whether there was a contravention of the provisions of the Act. The revenue would rely upon Rule 138 of the rules to state that the appellant ought to have ought to possess a valid e-way bill, and admittedly, when the vehicle was intercepted, the time stipulated in the e-way bill had expired. Rule 138, though sub-rule 10 of Rule 138 lays down the validity period for an e-way bill. The proviso, second proviso in sub-rule 10 provides that under circumstances of an exceptional nature, including transshipment, the goods cannot be transported within the validity period of the e-way bill. The transporter may extend the validity period after updating the details in Part B of Form GST EWB-01. The third proviso states that the validity of e-way bill may be extended within 8 hours from the time of its expiry. Thus, the rule gives certain latitude, and therefore the conduct of the transporter is required to be examined, bearing in mind that the rule itself provides for extension of the validity period of the e-way bill, and the transporter has been given a latitude of 8 hours to seek for such extension. If that benefit is granted to the appellant, then the time which was spent, the delay, not time, the delay would be about 1 hour and 35 minutes. The email, where is that email sent? Email of L&T. They sent an email.
26, page number 26, Your Lordship. This page number
Further,
26.
the consignee, L&T Construction, had sent an email on 15th May 2022 stating that initially the goods were consigned to Kankora, Kankora, near Shantirikentan Road, Tirlok Chandrapur, Budbud, Panagraha, Durgapur. However, subsequently, the consignee thought of bringing the goods to another yard located at Degal, Degaul Avenue, Durgapur, and the officer of the consignee accordingly communicated the same. The consignee also expressed regret for the inconvenience caused and requested them to deliver the material at initial address only, that is Panagraha, Durgapur. Admittedly, the vehicle was within the area of Durgapur, and even as per the revenue, the distance between the place where the vehicle was intercepted and Panagraha was about 20 kilometers. There is no other allegation against the appellant. Therefore, considering the peculiar facts and circumstances of the case, we find that this is not a case where penalty, that too 200% penalty should have been imposed. For the above reasons, the appeal, the writ petition is allowed, and the order passed by the appellate authority dated 26/9/2022 and the order passed by the original authority dated 15th May 2022 are set aside. Consequently, the appeal also stands disposed. This Sriram judgment, we will return it to you.
It will be required in the next.
Next.
My
This
lord,
one
my lord, he will not be entitled to pay any penalty because 200 your lordship is saying is then
no penalties.
some
Item number 3. My lord, I am for the petition. my lord.
এটা judgment appeal होती है।
Yes.
So the single bench order is last but 3 pages, my lord. Whereof, my lord, my application was displaced, my lord, on the grounds that I have not come with clean hands, my lord. Well, the fact of the case is,
Yes.
well, the fact of the case is that although I filed a nil return, my lord, the taxes were paid, my lord. The taxes under the Service Tax Act was paid. My lord, my demand, according to the order, in, my lord, I'm cutting it, my lord. I'm not going into the deep of the matter, my lord. My demand as per the order in original was 1,48 lakh, something, my lord. And we had already paid 1,44 lakh order. There was a difference of 6 lakhs only. Well, during the pandemic period, my lord, this order were passed, my lord. I did not receive the, according to my instruction, my lord, the petition did not receive the order in original, my lord. So the appeal was not filed, my lord. But subsequently, my lord, this happened in sometime in the month of March 2022, my lord. In the month of my lord, October, my lord, I received a letter that this amount is outstanding, my lord. As because an order in original has been passed, my lord, and to take care of the demand, my lord. Demand, there is a demand, there is an interest, there is a penalty, my lord. To take care of that, my lord, I need to file an appeal. Otherwise, I am out. The demand can be quashed, my lord. The penalty and the interest will stay, my lord. So I wrote a letter to them that I have not received the copy of the order, my lord. My lord, instead of, my lord, they giving me the copy of the order or intimating me that it has already been served, my lord, what they did was they attached my bank account. I again wrote it that this is the detail of the payment, which according to which, my lord, 1,44 lakh has been paid, my lord. My lord, the letter is in page number, my lord, 73, my lord. And the details, my lord, is already in page number 50 to 54, my lord. But now, my lord, as because I had in my petition, my lord, I have taken an I have taken a paragraph, my lord, where I said that I did not receive the copy of the original, my lord. My lord, on this ground, this petition was dismissed.
No.
And
records were produced to show that the order in original was served on the appellant. And after several
it was not
notices of hearing, which are duly received with the appellant, and therefore the court said you have not come with clean hands.
My lord, two things, my lord. My lord, it was not served upon me so that I could give a reply to that. Number one. My lord, the dealer might do that.
They have produced document to show that you have been served with the order in original.
My lord, prima facie, until unless I do not get the copy of the document, my lord, I cannot rebut it. My lord, second of all, my lord, my submission is...
No, how will you get over this? The learned judge has said that you have not come with clean hands.
My lord, what I say, my lord, the dealer might be bad, my lord. Can the department be worse, my lord, without giving the credit of the demand? The taxes paid, my lord.
No, the demand is 1,48 lakhs.
My lord,
page 68.
My lord, the tabulation is made up in page number 7 of the application, my lord. The appeal, my lord.
Yes.
My lord, the box, my lord. The demand service tax payable as per demand, my lord. The fourth box, my lord. My lord, the next page, my lord, 1,48, 64, 195. And my lord, the service tax paid is 1,42 lakhs 56,345.
Now they are not. They will give credit to that if it is already been paid.
My lord.
See, they can confirm the demand of service tax.
My lord.
At 148, 64, 195.
My lord.
And whatever amounts have been paid, they'll give credit to that, and the balance amount you have to remit.
And my lord, as regards to the penalty and the interest, my lord, has to be recalculated, my lord. But my demand was only to this extent, my lord.
That is correct. On what date you paid this 1 crore 40?
Page number, my lord. The details are in page number 50 onwards, my lord. 50, 51 is for 1415.
What is your instruction, sir, on this?
My lord, they had a provision of appeal, section 80.
That he has not, he has missed the...
He has not. Once he has not done, then he has come to the writ court and said that I have got a natural justice violation because order in original not served. Now I have produced document before the honorable court. Here also I am having those documents to show. Order in hearing notices was given. Order in original was given. Now he choose not to file an appeal. Now, Lordship, what we are finding in the department, many writs we are getting that order in original or not. Then either time is extended or something. And this all happens when we start recovering and attaching, Lordship. So, Lordship, then on that occasion, in this instant matter, we took a point. Now we have served it. He has got anything, then he can go back to the court under section 85, he could do it. Or else, of course, he will get whatever he has paid. I will not recover twice being in state. So rest I will recover, and the penalty interest also I will recover. Because
if you give credit to 1 crore 42 lakhs,
we will.
And if there is a, suppose let us say, within 15th he had to pay, there was a delay, then automatically interest is payable. You recalculate the interest, and then recalculate the penalty also on that, and you pass a fresh order.
No, Lordship, in that case, in the effect of that is my order in original. My order in original is being touched and it has given a go by.
No.
At Lordship, kindly visualize what Lordship is saying, and I'm absolutely in.
No. So whatever he has been guilty of not paying service tax, that we will confirm.
Lordship is only trying to look into, I should not recover more interest than what is mine.
No, you recover the deficit. 148 is payable. According to him, 142 has been paid. The difference in service tax has to be paid. Even in that 142, if there was corresponding delay, interest is payable. Then you recalculate the penalty based on that. So we will not touch any finding on the merits. Only in respect to the operative portion of the order in original, directing you to give credit to the amounts and recalculate. Suppose you pass
equity wise, Lordship is Lordship, this should have been.
If you do that, if he complies with the demand, one opportunity you may have to file an appeal against the penalty alone. So by that, the revenues interest also will be protected. We will not accept, we will accept your case that he has been served with the order in original, there the plea which was raised was false.
So that's crystallized.
That is false.
That's a decree crystallized. Now in the executing court will record that. Now, Lordship, there is one issue before Lordship delays. Lordship, kindly visualize the situation. If this is being allowed, that means a file which has been completed, attained finality, is being reopened by the writ.
No.
Lordship, kindly see.
You are bound to give credit to whatever he has paid. You are bound to.
We have given.
No.
Now Lordship, I have done it.
See, what if suppose pursuant to the order in original, if you have raised a demand now, and in that demand you want 1 crore 48 lakh, then it is wrong.
No, that we have not done.
Where is your demand? Where is your demand?
Then Lordship, in that case, I will take a specific instruction in this regard and I will come back on that.
Adjourning the matter is so difficult. You please understand the department is finding it. We will give you that liberty. All other findings will be wholly in your favor. This intra-court appeal by the writ petitioner.
Then Lordship, kindly record one other point submission of mine. Lordship, I have given a notice of hearing. He has come or not come according to his view. I have formulated my opinion. Now, Lordship, the calculation I have
only the computation
according to Lordship. In that case, Lordship, what has fallen from your Lordship, that the calculation has to be recalculated and the interest penalty will be this. So, Lordship, penalty which I have imposed, Lordship, is not also touching that point, probably. Only the interest.
No, penalty also has to be recalculated by after giving credit to that 142. It's a consequence, no? On that equivalent amount of penalty. Whatever is the deficit.
No, Lordship, then in that case, I have to understand when he was supposed to pay and when he has paid.
Yes.
No, Lordship, if that, he filed a nil return.
Yes.
Since he just submitted before your Lordship, he filed a nil return. I cannot, please. Sir.
But thereafter he has paid.
No, Lordship, once he has paid a nil return, then I won't be able to calculate when he was supposed to pay and when he paid. Now I have got two dates. One date is filing of the return. Second date is directly payment date. Now, as he has not filed the return on the time date that he is supposed to pay this, so I will not be able to in a position to calculate that.
Should I submit, my lord? Well, lordship comes down to page number 50.
And he has only, and the date of the payment, if we can look into lordship, then that is after the date of the show cause issued.
Suppose he has completed it, my lord. But the last word he has said that the date of the payment is after the show cause, my lord. Show cause was issued in 2020, my lord. 15, my lord, page number 51, lordship comes down, my lord, serial number 1, date of payment is 24/4/2014. 2014, my lord, for April. Thereafter, my lord, 22/6/2014. My lord, all, my lord, from the top to the bottom, for the period when 14-15, it was paid in 14-15. My lord, subsequently, my lord, for the period
for calculating interest.
Let me complete it. Let me complete it.
I'm so sorry.
I did not interrupt you.
I'm so sorry.
My lord, in page number 52 for the year, my lord, 15-16, my lord, 15-16, I paid it, my lord. My lord, whenever, my lord, the dealer made a mistake, my lord, his consultant made a mistake by filing a nil return. But the dealer, admittedly, my lord, fair enough, my lord, he had paid already all the total taxes, my lord. Only there is a difference, my lord, as per the calculation, there is a difference of 6 lakhs, my lord. I'm agreeing to pay that 6 lakhs. But I'm not stopping, my lord, them. I'm telling, let them collect 6 lakhs. My lord, let the penalty and the interest be recalculated as because, my lord, the GAR, my lord, the challan, my lord, when they are passing an order, my lord, they ought to have seen it, my lord. Well, I might be bad, my lord, the dealer might be bad.
But the problem is you didn't appear.
But that is, my lord, before the SOCOS notice, my lord, I appeared. Well, before passing the SOCOS notice, I appeared, I filed all the documents. It is in record, my lord. In the SOCOS notice, it has been admittedly placed, my lord, recorded that I appeared. I myself gave all the 2023s returns, balance sheet. Thereafter, they went to my office. They took the details from there, my lord.
3 opportunities were granted. You did not even give a reply to
Those were pandemic times, my lord. My lord, the dealer is a proprietor who is of near about 75 years of age. Well, pandemic time, they were not receiving their money from the government, my lord, against the execution of the contract, my lord, and neither could they pay the staffs, my lord.
Lordship, he said I paid in this year. Whether it is connected to my show cause demand notice or not, I cannot go and look into again.
My lord, this has been verified.
I am saying, because
then we will grant him liberty to file an appeal. If you say that that 142 he will not reckon, then we will grant him liberty to file an appeal.
that's certainly not.
But the problem will be to extend the time of period of limitation, which
That's a
normally
statutory bar, Lordship.
therefore normally the writ court should not do that. So the best thing is you give credit to whatever amount is paid.
No, Lordship, then Lordship, if we reopen it, Lordship, then that's what I said. Lordship, I will come back with my queries that to do it, what are the things required? Because the document I have as is today, moment Lordship gets them free, I will not get my...
Mr. So-and-so, and Mr. So-and-so. The petitioner had challenged the order in original, demanding service tax and imposing penalty. The case was that the copy of the order in original was not served on the appellant. This was established to be a false statement, and therefore the learned writ court dismissed the writ petition. Agreed by the said order, the appellant has filed the present appeal. The case of the appellant is that on account of wrong advice, a nil return had been filed. But the fact remains that service tax was paid from the year 2014-15, and the total amount which has been paid by the appellant is rupees 1,42, 56, 345, as against the demand of rupees 1,48, 64, 195. The appellant is ready and willing to pay the balance amount of 607,850. And the only prayer made by the appellant is to give credit to the payments already made, consequently rework the interest and penalty, and pass an order. The prima facie, the stand taken by the appellant appears to be reasonable. The full stop. However, the learned senior standing counsel for the revenue would point out that there may be a difficulty for the department to reopen the matter. In any event, if already amounts had been paid on various dates, as has been shown to us from pages 51 to 54 of the stay application, those payments have to be given credit to. And if the same is given credit to, the amount has to be reworked. Therefore, page 44.
May I make a small submission, my lord?
Further on perusal of the show cause notice dated 29th December 2020, we find that the computation has been done and the demand the demand was proposed based on the work order. Therefore, prime facie we are of the view that the total amount payable can always be reworked. Since the learned advocate appearing for the respondent seeks time to get written instructions in this regard, we are of the view that the following interim direction should be issued to protect not only the interest of the appellant but also the interest of revenue. There will be a direction to the appellant to pay the sum of ₹6,07,850 within 2 weeks from the date of receipt of the server copy of this order. If the said payment is made till the next hearing date, the demand for payment of penalty as imposed in the order in original dated 30/3/2022 shall remain stay. List the matter on so and so date.
My lord, in fact, my lord, actually they have already verified it as because there was
You
an
pay
order of
that
a
6
single
lakhs.
bench,
You pay the 6 lakhs.
my lord, I'll pay.
There will be a stay on penalty alone.
My lord.
Let your learned friend get written instruction based on
But
that.
in the meantime, my lord, my bank account be opened, my lord, setting aside 20 lakh, my lord.
In that case, Lordship, let them deposit the interest and penalty and let them bank.
Penalty we have to cease.
My lord, I am paying 6 lakhs, another 20 lakhs rupees be kept aside, my lord, and the bank account be open.
Lordship, then in that case, let them deposit that amount with the register of this court, not to me.
Why this?
My lord,
Why should you take that money?
Lordship, Lordship, may I request another small?
The learned advocate appearing for the appellant submitted that the court may also impose further condition, since further condition which the appellant will comply, and a direction may be issued to the respondents to lift the attachment of the appellant's bank account. In the light of the said submission, we direct that the appellant to deposit a further sum of ₹25 lakhs to the respondent department, which shall abide by the further orders to be passed in this writ petition. On compliance of the twin conditions, the twin conditions, namely the payment of 6 lakhs and odd, so and so on.
31 lakhs.
₹25 lakhs. The attachment of the appellant's bank account shall be lifted. List the matter on 12th May. Until then, there will be.
Absolutely. Lordship, only one request, Lordship. Meantime, I will call him with all the record. Let him be produced before my authority. We can calculate and
in the event the respondent department requires any details to be furnished by the appellant, notice shall be issued and the appellant shall appear before the authority
fixes a date, my lord, I'll go.
and cooperate with the queries that may be raised with the department. Next.
I don't
Grateful
know.
Lordship.
Court.
Grateful Lordship.
May it please your lordship. May it please your lordship. The writ petition was not, it was filed on the 9th of March. And it got listed not on the 17th of March. And so by the time it was taken up, the assessment order had been passed on 29th of March, but it is digitally filed on 30th of March. So when the matter was taken up, Lee was afraid to file a supplementary affidavit to bring the assessment order on record. But the court was pleased to dispose of the matter, giving findings on the 148 AD order, and with the observation that there's an appeal provision.
But that correctness of 148 AD order can't be challenged in the reopening.
Lord, the only thing, Lord, the writ petition was filed, Lord, almost after a year after the 148 AD order was passed.
Oh, is it? There is a delay also.
Yes, after that order was passed, immediately after that, because the observation that there is no violation of natural justice, that observation is not quite correct. I will show.
Where is the reasons for reopening?
Yes, kindly see that 148 AB notice page 174. May I invite my lords to have a look at the color printout? That is better because there's some of some relevance there. Kindly have a look at this. My lords would have noticed at page 170, I put down the page numbers in pencil. It's the same document, just to correlate with the appeal papers. There's that yellow piece of paper, and my lords will notice that mostly the second piece of paper is mostly blank. Now, then at page 176, the last 4 lines, so there's mention of a statement of one Anjani Kumar. Then at page 177, middle of the page, there's mention of a statement of one Anup Maji. Then at page 177, again, a screenshot, the second, just above the table, second line, a screenshot of file. My lord, is
page 177.
177, just above the table where the table starts. The second
screenshot of the file.
Yes, so this screenshot is given. This also has some significance. I'll show. So this was what was given, and then at page 180, after the table ends, it is found from the public domain and information gathered during the course of such proceedings that Krishna Tissues has a factory in Burdwan. Krishna Tissues Private Limited is also known as Krishna Tissue in short. Companies engaged in manufacture of paper and paper-related products. Company has purchased huge coal, slacks, and other products which have been utilized in its manufacturing activities. Therefore, the beneficiary mentioned as Krishna Tissue in the incriminating documents seized from the business premises of Ratnesh Verma relate to Krishna Tissue. Again, will not mention of incriminating documents. Krishna Tissue has purchased a substantial portion of its coal from Maji Group. Company has purchased the coal in cash and obtained bogus bills from accommodation entry operators. Company has obtained bills from accommodation entry operator without actual receipt of goods. Assessing officers requested to verify the creditors for coal purchase during assessment proceedings and check the respective purchase bill, e-way bill, bank payments pertaining to coal purchases. These cash purchases are liable to be taxed under section 69C, read with 115 BBE. Then for our year 17-18, the amount is 11 crore 17. And then the summons under section 131 had been issued on 16 January 21 through ITBA, but no satisfactory reply had been furnished by the assessee in personal summons. Hence, cash purchase made by the assessee during financial 17-18 relevant to assessment 18-19 amounting to 11 crore 17 requires further analysis, investigation, and verification as per provisions of IT Act. Conducting of inquiries in the above case is not required under section 148 AA, as the information in this case of the assessee has been flagged as income chargeable tax has escaped assessment in accordance with the risk management strategy formulated by the board. So then I was asked to show cause. Now that yellow document, kindly take it once again at page 176. But the way it was given, just the name Krishna is mentioned. But in the second document, just the name Krishna,
Krishna.
that is all that is mentioned. Now, after I got this note, I wrote a letter, which my lords will find at page 184. I'll take my lords straight away to page 187.
Yes.
Paragraph 4.1. 4.1 it sort of summarizes what the notice said, what are the statements. So then thereafter, after that the bullet points from the above, it shall be evident that the information does not relate to the assessee company, that is Krishna Tissues. Information relates to some Krishna or Krishna Tissues, and on surmises and conjectures it has been alleged Krishna Tissues Private Limited. Next, your good self has placed reliance on statement of Anup Maji and Anjani Kumar. However, statement of said persons along with opportunity of cross-examination not provided to the assessee. Then 188, further it is stated that after analysis of incriminating documents pertaining to sale and transport of coal, it is observed that huge quantity of coal is sold to Krishna Tissues. These documents on which reliance is placed has not been provided to the assessee. Further, screenshot of file in annexure also does not contain name of Krishna Tissues. So I took the factual that you have not given me. There's a screenshot which doesn't mention my name. There's a document which mentions Krishna. So please give me all these materials, the statements which you're referring to. And I ask for all that. Now, what he does, he passes an order.
But ultimately at page 195, it in fact says drop the proceedings.
Yes, because I say that I actually don't know the man. I have not had any dealings with him. So to drop it. But I make it a point that please give me those. So the order that he passes thereafter, if my lords are pleased to see page 196. This 196, kindly have a look at the colored printout that is again of some relevance. Page 3, running page 198, if my lords are pleased to take note. It is the same document with the word Krishna on it. And then at page 200 is that chart, the screenshot. Why I'm drawing attention to the screenshot is that subsequently a very different picture has emerged. The document which they provide later, but I shall just come to that. And then kindly see what he has to say at page number
Up to page 203, it's an extract, virtual reproduction of the allegation in the show cause notice.
yes, then kindly see on page 204.
Yes, 204.
But in response to notice the paragraph after that, in this regard, the details information regarding details information in modus operandi has vividly described in the show cause notice. All relevant documents has duly analyzed with ITR 26AS, AIS data, 360-degree profile and other documents available on record. However, if you wish to cross-verify, cross-examine the evidence in respect to said information, you may do the same after taking prior appointment from the undersigned. So he does not give me anything. He just gives me one yellow piece of paper. But then he says screenshot, which is not.
But he has given an opportunity saying that please come and meet me.
Yes, so then I write to him that under the law, you have to give me the document.
This order was passed on 25th of March.
Yes, ma'am.
On what date he has written, the assessee wrote him,
But on page 18th April 2022.
Page 207.
Yes. Page 207, and if my lords are pleased to take note, at page 214. Kindly not take page 215. Para 7.1 where the reply reproduces his observation in the order. Because as I submitted that if I may just pause him, he passes an order and then he says you come and have a look. So that is a very serious grievance. That if he has something, then the notice has to give it to me, or not he has to call.
All right. What was his reply to the 18/4/2022?
He does not reply. He does not. He comes to me after 10 months. In February 2023, which is at page 224. He asks for various details, and my reply is at page 233, where I again 233 is the evidence of filing at page 234, and if I can draw attention to page 237.
This is after you received this 142(1) notice. One more objection he has
Yes,
given.
because my stand was that the law requires you to give it to me, because you have the documents, you have the data, then you have to give it to me to deal with it.
Now this was on 13th of February.
Yes. Now then he issues to me a notice under 142. 143 that I have placed. Then what he does is thereafter, kindly take page 297. No, I'm sorry, 297 is my reply. But kindly give me a minute. I'm. What is the next document? 13th report. But yes, not page 243. I'm sorry, I made a mistake. 243.
43.
243.
Yes. This is the second 142(1) notice.
Yes, this is the second 142(1), and this is quickly followed by a notice dated yes, I replied to this at page 297.
We don't have 297.
But it's in the second volume. 297, the last paragraph on the first page. I again reiterate my request for documents.
And you filed a writ petition.
No, thereafter, my lord, yes, my lord, I filed the writ petition at that stage, my lord, on 9th of March. And then, my lord, during the pendency of the writ, my lord, I got a show cause notice, which is, my lord, at page 312. But kindly take the printout, the color printout of this document.
Here, the another tax invoice is shown.
Yes, my lord,
It
it's
says
the
Krishna
same,
tissue
my lord, it's the same document.
and somebody has filled it up.
My lord, I do not know, my lord, that this is the whole, my lord, a demand of 11 crores based on, my lord, 2 pieces of paper and a screen, 1 piece of paper, 2 pieces of paper screenshot. My lord, that's why, my lord, I was drawing attention, my lord, it is the,
So GST TIN number is same.
my lord, kindly see, my lord, if my lord, please to.
So if you compare this with that,
Yes, my lord. No, not the note. This tallies. The currency note tallies, but not the
no,
document itself.
this document tax invoice,
Yes,
the GST number given in page 197
my lord.
tallies with 314. Correct? Handwritten GST.
No, that is a, yes, no, that number tallies. Yes. Yes.
So who placed the 10 rupee note and they took a photocopy?
No, there are 2 pictures that they have given. One is of the 10 rupee note, and the other is of the document. This is what, not they say in the.
In that document also,
Yes, ma'am.
the vehicle number tallies 53B8030.
Yes, ma'am.
Dated 2/11.
Yes, ma'am.
But in this tax order notice, the full tax invoice is shown, giving Prahalad road line.
I'm not at if my lords are looking at not page.
No, of course, what you are saying is, in what was given in page number 196 or 198, contains the name Krishna. Page 314 says Krishna tissue Bardwan.
Look, there's another aspect. Look, can you see at the top? Look, page 314 shows not Messrs. Prahlad road line with all those details. Look, at page 198, note that portion is blank.
Messrs.
So, look, and then look, the product description is of which is blank at page 198. And
because the invoice, the continuing printed number is correct, 118.
Yes, well, that is why I said it's the same document.
Yes, same document.
Otherwise, I couldn't
they filled it up later.
So, I do not know what has been done. I will not cast any. It is a very serious thing to make that allegation. In fact, the draft.
Because what they allege is for fake documents.
In fact, I will be very candid. When this, since the matter was pending and they received the show cause notice, they came to me with a draft saying, making very serious allegations. I said, please don't do this. It is, we question the document, but whether there's anything which has been.
I think precisely for that reason, when he issued you the notice under at page 243. No, not. We're losing track once again. 234. 234 is your representation. No, that is why in this 148 AD order, he says, if you want, you come to me.
I responded to that. I said that please give me the copies. The law enjoins upon you to give me the copies. Because if they have documents relating to me, they should give it to me. That is what the law is. Because I have to consider.
But why was it getting time barred or anything?
The March 2023, it was getting time barred. But there's one more aspect. My lords have that page 300 and 300 and along with this 312, there's a page 317 onwards. There's a which is a detailed statement. This came as an annexure A. Now, this is supposed to be the same document of which a screenshot was given to me originally. Now, kindly see that screenshot. Note at page 200.
Page
200.
Yes. Yes.
Well, even the headings don't match. There is no column for factory. There's no column for value. So my answer in the show cause was that this is probably a tabulation done by the authorities. This is not a seized document.
But after the AD order, now he is once again trying to, by issuing 142(1) notice.
Lord, 142 will come
This
after.
is 143(2) notice.
Yes,
Case is getting expanded.
yes, and I'm not. Thereafter now the order that he has passed, not here all along he was saying 11 crore 11 lakhs. Now he's added 8 crore 80 lakhs. So he has the assessee is completely not in the dark. This is not the therefore the natural justice violation.
And this is the explanation for your delay in filing the writ petition.
I was repeatedly asking him for the documents. When I found that letter of 8 March, in fact, I said that, look, you're not giving me anything. I have no option but to go to the court. But I said,
yes, you have said in the process of filing the writ petition.
Yes, because I was completely helpless. I wanted to meet the case. But if I'm not being given anything, page 297 at 298.
He could have given him an opportunity, sir.
And then kindly see the order which is passed. Kindly take that colored copy of this also. Order is annexed. Order is annexed is the. I don't need to show from the page 339. If my lords are pleased to see me. But my lords will see the. But it is my duty also to place one more thing before I take my lords to page 339. Kindly also see page 315. This was the notice which he issued to me on 16th March. Not at page 315. It starts at 312 at 315. This table which is there with a seized document reference. This has appeared in the notice for the first time. It was not there earlier. This table of seized documents, seized ID mark, it has come in the notice.
341.
315, which is again reproduced in 341, 342. This was there in the 143(2).
But in page 342, para 6, he notes that you have moved the writ petition, etc. Honorable High Court, Calcutta has not passed any order in the present case directing undersigned to refrain from making assessment. Failed to note the proceedings is bound by time limitation as per 153. Therefore,
I'm not the document at page 341 is that filled up document, if I can call it that that Krishna tissue Badwan, that whole thing is there, which was not there in the notice, the first notice, and 148 AD order, and then page 344, the screenshot.
Yes, what do you say, sir?
With these
so much of waste time is lost. First instance, when he issued this notice, the problem lies with the assessee also. If you read the reply at page number 184, that's the first reply.
184.
In page 180.
187, I drawn.
187. Next your good self, so and so, so and so. However, the statement of the said person along with the opportunity of cross-examination is not provided to the assessee. Further, it stated analysis these documents has not been provided to the assessee. further screenshot, etc. But ultimately they say, go and drop the proceedings. If they had said, please furnish all these things. So this is my interim reply. I will come back to you after you get the documents right.
And Lord, there is one more thing, Lord, if your Lordship sees, please, page 205.
Yes.
Lord, second last paragraph. Hence, from the above discussion and from the surveillance data and the analysis by the investigation directorate, it is evident that the escapement of income by the SSC has happened in this case, as full information has already been provided to the SSC. It can be clearly seen that detailed inquiry has been done, and only after that exhaustive report has been prepared by the investigation directorate. Lord, as if Lord, during the investigation, Lord, only information was provided to the SSC. Lord, this is what Lord he's trying to hint at.
But somebody has written with hand, not provided at all.
Yes, Lord, this is
That
Lord, I
comment
think,
has
Lord,
come in hand. I'm sorry, it shouldn't have been there.
No.
Lord, but this, when,
But
when
the fact remains, he was not given the, actually what they done is, this is all part of the test, coal scam. In that, they've got some documents.
yes,
And they said that they're all bogus documents. There is no goods being transported, but shown bills have been raised and some entry operators are involved. That's the allegation.
No, the
yes, that is
allegation,
the
note, if I may humbly put it, is this note, that I have bought coal in cash from this gentleman. And I have, in order to put it in my accounts, I've taken bogus bills and I put it in
As
my
if
account.
they were transported by these vehicles to your,
Yes, so that is the allegation that I bought in cash from somewhere, I've taken the documents of somewhere else. So in, as such, the expenditures,
but the fact is Krishna Tissue has purchased coal.
and it is in the records.
And this is your, the allegation as rightly said, the assessee purchased in cash and used certain documents
Documents to put it in the books.
Lord, and one of the department, Lord, allegation in the sense that the assessee was in the know of the documents, or he was in possession of the material on the basis of which the investigation report was prepared. My Lord, this allegation has not been denied by the SSC, my Lord, in the reply that he gives later on, my Lord, to 140, my Lord, the
But
148.
why this man, when he passes a 148 order, he need not have said that if you want, you come to me.
Yes, my Lord, this is actually, my Lord, 148 AD order, my Lord, in 148
AD order.
AD order, my Lord. Thereafter, my Lord, the 148 proceedings reassessment will start, my Lord.
No, then he should not have passed AD order.
Yes,
He should have.
that is there, my Lord. That is there, my Lord. But this aspect, my Lord, that he the investigation directorate had filed the completed the investigation report upon providing the documents to the SSC, my Lord. This the SSC does not deny, my Lord. He extracts this. If your Lordship sees the SSC's answer to this, my Lord, at page 214. Lord, page 214, last paragraph. My Lord, the entirety of what was quoted, my Lord, in the 148 AD order, my Lord, has been extracted. In response to the notice, my Lord, the italics portion is the extraction. My Lord, at page 215, second last paragraph in the italics, my Lord, is the relevant portion where Lord, he doesn't deny that he was never provided a document by the investigation directorate.
Investigation directorate will never give me any document. They are inquiring. They are not giving me any opportunity.
Lord, but
I do not know what
that is behind his back.
Lord, if the investigation, Lord, in cases, Lord, where investigation is done, if persons, Lord, who are said to be accused, Lord, then they are provided with documents, Lord, to confront that before preparing the report. That is there, my Lord.
My learned friend is making submissions from the bar. There is nothing on record to show.
Lord, this has not been denied. That is what I say, my Lord. If it has not been,
But this observation at page 204, if you wish to cross-verify, cross-examine the evidences in respect of the said information, you may do the same after taking prior appointment from the undersigned. That itself means that matter should not have attained a finality. And he has been writing this intra-court appeal by the writ petitioner is directed against the order passed by the learned writ court dated 3rd April 2023 in WPA 1605 of 2023. by which the writ petition was dismissed, stating that the reassessment order has already been passed under section 148 of the Income Tax Act, 1961 within bracket the Act. And what was impugned in the writ petition was an order under section 148 capital A within bracket small d of the Act, dated 25/3/2022. And the reassessment order being not subject matter of challenge in the writ petition, the court held that it cannot go into the merits of the reassessment order. The correctness of the order passed in the writ petition has been challenged in this appeal. You have elaborately heard the submissions of the learned senior advocate appearing for the appellant and the learned senior standing counsel for the respondent department. Though the facts are a bit complicated, but all that we are required to see is whether the appellant had been afforded reasonable opportunity by the authority in the reassessment proceedings. The reassessment proceedings commenced with the issuance of a notice under section 148 capital A within brackets small b of the Act, dated 11/3/2022. In that, various allegations have been made. Screenshot of certain documents have been extracted, apart from other information. On receipt of the said notice, the assessee submitted a letter dated 21st March 2022. Though ultimately the assessee pleads that the reopening proceedings should be dropped, in the body of the said letter, a specific the assessee, and the body of the said letter, assessee has pointed out that the information which has been mentioned in the show cause notice does not relate to the assessee company. And the information relates to some Krishna, inverted comma, or Krishna tissues, inverted comma. And on surmises and suspicions, it has been alleged that Krishna Tissues is Krishna Tissues Private Limited, comma, the assessee. Further, the assessee stated that the assessing officer has placed reliance on the statement of Sri Anup Maji and Sri Anjani Kumar, page 187, spelling if you want, and pointed out that the statement of the said persons, along with the opportunity of cross-examination, has not been provided to the assessee. Further, it was mentioned that in the show cause notice, it has been stated that certain incriminating documents were analyzed pertaining to sale and transport of coal. And these documents on which reliance has been placed has not been provided to the assessee. Further, it was pointed out that relying on information which were gathered from various sources, without providing the assessee a copy of the same, violates the principles of natural justice. This the assessing officer, on receipt of the said letter dated
21st March 2020.
21st March 2022, did not reject the request or accede to the request made by the assessee, but proceeded to pass an order under section 148 capital A within bracket D dated 25/3/2022, which was impugned in the writ petition. Interestingly, in the said order, the assessing officer probably was of the view that an opportunity was required to be given to the assessee, and therefore stated that if the assessee wishes to cross-verify / cross-examine the evidences in respect of the said information, they may do so. Do the same after taking prior appointment from the assessing officer. After having stated this, the assessing officer proceeds to hold that from the surveillance data and analysis of the analysis by the investigation directorate, it is evident that the escapement of income by the assessee has happened in the case. Further, the assessing officer states that full information has already been provided to the assessee, and it can be clearly seen that detailed inquiry has been done, and only after the exhaustive report has been prepared by the investigation directorate and further analyzed by the assessing officer before issuance of show cause notice after obtaining prior approval from the competent authority. Thus, we find there is a inconsistency in the stand taken by the assessing officer. If the assessing officer was of the view that opportunity to cross-verify / cross-examine the evidence has to be granted to the assessee, that should have been done prior to passing an order under section 148 capital A within bracket small d of the Act. Thus, that apart, the allegation that full information has already been provided to the assessee appears to be not correct, as what is referred to by the assessing officer is the surveillance data and the analysis by the investigation directorate, which has not been provided, which information has not been shared with the assessee. On receiving the order passed under section 148 capital A D of the Act, the assessee submits another representation on 18th of April 2022. Pointing out various issues and stating that the fundamental principles laid down for reopening the assessment has been given a go-by. After receipt of the said representation dated 18th April 2022, the assessing officer issues a notice under section 142 within bracket 1 of the Act, dated 2nd February 2023, which contains annexures and annexures. On receipt of the same, the assessee submits a reply on 13th February 2023. once again pointing out that the reassessment proceedings right from the inception is bad in law. No reply is given to the assessee, but another notice under section 142 within bracket 1 dated 2/3/2023 has been issued along with annexures. Followed by a notice under section 131 within bracket 1 capital A. Summons, sorry, not notice. Summons under section
That's
130.
an old document.
Oh, sorry, sir.
That's
Not,
the, but,
oh,
page
it's in
two-
volume 2, no?
Page 297. The reply.
You strike out this. Thereafter, the assessing officer issues notice under section 148 of the Act dated 25th March 2022.
No, I'm sorry, those are old documents. Can you take page 297 of these? Sequentially, that is what will come.
Oh, 29.
297.
You strike out there. Thereafter, the assessee submits another representation on 8th March 2023, pointing out once again that how the statements of third party have not been given and an opportunity to cross-examine those third parties have not been provided to the assessee. The assessee also specifically informs that they are left with no option except to file a writ petition before this court. And accordingly, a writ petition was filed on
9th of March 2023.
9th of March.
Yes.
9th of March 2023. However, the matter was taken up for admission only on 17th of March 2023, correct?
It was 17th, it was listed, it was taken up on 3rd April.
It was, the writ petition was listed on 17th of March 2023 and taken up for hearing on 3rd April 2023. By then, the assessing officer had passed the reassessment order dated 29/3/2023.
But he had issued that was notice note at page
312, my lord.
12.
Lord, there is a
Pardon?
reply in connection with the objection dated 13th of February 2023.
Sorry, sir. Before that, thereafter, another notice.
Lord, this is a reply in connection with their application, with their
And a
response.
show cause both, Lord. The reply and show cause, the
Page 335.
312.
312.
This is the letter note. First part deals with my previous letter. Second part at 313 is a show cause notice.
Sorry, please strike out there. Thereafter, the assessing officer sends a reply dated 16/3/2023 for the representation/objection given by the assessee dated 13/2/2023.
And the show cause part is at page 313. Note. The bottom of 313.
The said reply contains an annexure, which according to the assessee contains details which were not disclosed at any earlier point of time.
Not only one thing, my lord, page 313, my lord, paragraph 8 and 9. Rather 9.
The reply dated 16/3/2023 contains certain annexures.
The replies at page 304. Lord. It's come earlier in the annexures.
Ultimately, the reassessment order was passed on 29/3/2023 when the writ petition was pending. The assessee sought to bring the reassessment order on record by filing a supplementary affidavit. However, the learned writ court dismissed the writ petition, stating that the reassessment proceedings are not subject matter of challenge and the writ petition cannot be entertained. On going through the reassessment order, we find that the assessing officer was fully, we find from paragraph 6 therein, that the assessing officer was fully aware of the writ petition which was pending before the court and yet to be taken up for hearing. And the assessing officer would observe that there is no order passed by this court restraining him or directing him to keep in abeyance the proceedings. And by referring to section 153 of the Act, the assessment has been completed. The dates and the various events have been set out by us in the preceding paragraphs, just to show that how the assessee has been dealt with in the matter. We have not examined the merits of the reassessment proceedings, but we have confined to the aspect as to whether there has been violation of principles of natural justice. The manner in which the reassessment proceedings have been taken through by the assessing officer is thoroughly flawed. The first fundamental error committed by the assessing officer is not to provide the third part, is in not providing the third party information, which was the basis for issuance of the show cause notice. Apart from making available those third parties for cross-examination by the assessee, when statements recorded by them, have been relied upon for issuance of the show cause notice. More particularly, is in spite of a specific request made by the assessee in this regard.
Only one thing, Lord, in the reply, which has been lastly given, Lord, by the assessing officer, he has indicated, Lord, that some of the persons, Lord, cross-examination whereof was sought, Lord, they are either in CBI's custody or absconding. Lord.
Fictitious. That apart, after passing the order under section 148 of the Act, the assessing officer could not have stated that if the assessee wishes to cross-verify / cross-examine the evidences, they may do so after taking appointment from him. In fact, such opportunity should have been provided prior to the passing of the order under section 148 capital A within bracket D. Thus, we are fully convinced that the procedure adopted by the assessing officer was wholly incorrect, and there has been serious violation of principles of natural justice committed by the assessing officer in the entire process. Therefore, the entire proceedings, therefore, the order passed under section 148 capital A within bracket D and the consequent reassessment order have to be necessarily quashed, and the matter should be restored to the position of the show cause notice issued under section 148 capital A within bracket small b of the Act, with a direction with consequential directions. In the result, the appeal is allowed and the order passed in the writ petition is set aside, and the writ petition is allowed, and the order passed under 148 AD of the Act as well as the reassessment order passed under section 148 are quashed, and the matter is remanded to the assessing officer by restoring the matter to the stage of show cause notice under section 148 capital A within bracket small b of the Act. The assessing officer is directed to afford an opportunity, furnish the documents sought for by the assessee, make available such of those persons whose statements have been recorded for cross-examination, and after complying with the principles of natural justice, proceed to finalize the matter in accordance with law. Since facts are complicated and various issues have been pointed out by the assessee, it will be a fit case where an opportunity of persevering can be granted to the authorized representative of the assessee. The assessee is not permitted to raise the question of limitation when the reassessment proceedings are done afresh.
Only one thing, my lord, the persons, my lord, whose cross-examination is certain, my lord, if they're in CBI custody or absconding, my lord,
See,
then
you
but
can,
that is what he has observed.
then that evidence has to go. You can seek for permission. They are inside prison, is it? Arrested and
Yes, that is what, my lord,
in
page
jail.
203 says, Lord,
Not all of them.
Not-
This Maji and another man, two people,
They have mentioned two people.
only two people.
So, my lord, those are the two people, my lord, whose evidences, my lord, have also been taken into consideration, Lord.
No,
Maji and
those two people are behind bars.
yes, my lord, that is what, my lord, I found, my lord, page 3.
Where do you get that?
Lord, page 313.
Then you take the SSC to the correctional home. There he
Lord,
can cross.
Paragraph 9. Vide point number 3, you have stated that opportunity for cross-examination has not been provided to you. In this connection, you are requested to note that several other investigating agencies are
Some key
investigating the
persons
case
are
of
with
Maji Group. As such, some key persons are
These
either in
people are not key persons. Key persons, Maji group. All right. Thank you.
I'm grateful.
Grateful.
Item number 5.
But my lord's officer may check the writ petition number. My juniors are saying that possibly it has not gone, the number has not gone down correctly. So they
Correctly.
may just check the numbers.
Repetition number all.
WP number, just check. I'm grateful.
Grateful.
Yes. No scope for passing interim order. Himanshu,
My lord.
no scope. Dismissed. What was the challenge?
My lord, the GST matter, my lord, and appeal, statutory appeal rejected on the only on the ground of limitation, my lord.
How many days delay?
After considering the Honorable Supreme Court limitation order, only 114 days delay, my lord. We are challenging
Without Supreme Court order?
297 days delay.
297. After Supreme Court order?
114 days delay, my lord.
But he can't condone it beyond 90 days.
Yes, my lord. We are also challenging the adjudication order also, my lord, because adjudication
Let
order
us see
also-
the adjudication order.
Yes, my lord. My lord, kindly first show cause notice at page 58, my lord.
58.
58, my lord. This is the show cause notice, my lord, and all the notices and order only uploaded in the portal, my lord, not served through email or post.
Not
Any other.
required. No?
My lord.
It is not required.
When my lord adverse decision and civil consequences, my lord, then all any
No,
other
no,
court
no.
may be.
Now courts are becoming paperless, then where is the question of
Yes, my lord.
mode of service as per the provisions of the act? This is registered email ID, that's sufficient. Or uploading in the portal is sufficient.
My lord, my lord.
Don't argue that point.
My lord. And this is the show cause notice, my lord. This unsigned show cause notice, my lord, and the one page show cause notice, no reason is stated in the show cause notice, my lord.
Digitally signed.
Digital sign, not there, my lord. Only no signature.
All
is
right.
there.
What is the allegation in the show cause notice?
My lord, the only operative part is page 63, my lord. No reason is stated, my lord, in the show cause notice. Page 63.
Total amount tax has been demanded, so and so. Outward supply as per GSTR 3B. Turnover difference, tax payable. 10 crores. No, 10 lakhs.
10 lakhs. My lord.
About 10, 100, 1000, 10,000.
And my lord, thereafter pass the order, my lord. And my lord, this tax, my lord, what happened in the fact, this the bills related to March quarter ending, and they calculated 18%. I am a small government contractor, and after receive of bill, I paid 12% rate and showed the turnover in the returns of December quarter, my lord. And I am also ready to pay the interest also. For that, my lord, the adjudication is required, my lord. And my lord,
What was your reply to the show cause notice?
my lord, no reply, my lord, because I have missed the, my lord, only upload in the portal, my lord. This is the first time notice, my lord, for the petitioner appellant, my lord. And my lord, pass the order without granting any opportunity of hearing personal, and this is very important factor, my lord. As per section 75, subsection 4, my lord, says, if I not request, even I have not requested for personal hearing, when adverse decision is contemplated,
adverse personal hearing is must, my lord. And different honorable High Court, division bench of different High Court, catena of judgment, my lord, only solely on this ground, non-granting of personal hearing, set aside the order.
Page 64 is the order.
Yes, my lord.
What do they say in the order? Show
In the-
cause notice so and so.
My lord.
For reasons mentioned therein, payment is this is not an order.
Yes, my lord.
No, in the order they will say that show cause notice was received, no reply received.
Operative part is, my lord, 68. Operative part, page 68. This is also non-speaking order.
No, this is form of order.
Have form of order, part of order. No
There-
details order given, man.
No speaking order.
No speaking order.
Must be available.
This was available. It was
It
available.
should have been uploaded in the
It was in the portal. That is my.
No,
instruction.
opportunity of hearing can be granted where a request is received
My-
in writing.
I'm grateful.
If you don't make request, how you will get?
No, my lord, section 75 subsection 5, my lord, 4, my lord, an opportunity of hearing shall be granted where a request is received in writing from the person chargeable with tax
All right.
or penalty, or, my lord, where any adverse decision is contemplated, my lord.
Your request is, forget it.
My
You
lord.
missed the bus. You didn't give a reply. Now 10 lakhs, 1,004 is the total tax payable.
Payable,
10% you paid,
yes, my lord.
10 or 20%.
No, 10%, my lord. Pre-deposit paid, my lord.
Where is the appellate authority's order?
Appellate authority order, my lord, at page 85.
85.
Starting page 85. And operating para 86, rejected the appeal. Last para.
And now they have issued a demand.
Issue the demand, and my bank already attached, my lord. Our date of knowledge is, my lord, bank attachment, because when the bank attached, my lord, then I came to know and immediately I filed the appeal, my lord. Date of knowledge of 12/9.
Now you are ready to pay the tax.
I have already paid the tax, my lord, because I have shown in the returns of that, my lord, at page.
No, you see page 87.
87. No, their calculation is mistake, because, my lord, they calculated 18%. I have the government contractor falls under 12%, my lord, on that period. And that tax I have paid, my lord, and shown in the return of
No,
December.
that should have been given credit. Where are you? This tabular column doesn't show
Yes, my lord.
that you are paid at the rate of 12%.
Yes, my lord. At page 69, my lord. This is the 3B return of the December quarter, my lord. I have paid that showed the supply 56 lakh 11136. Column 3, my lord. And paid the taxes.
Page 69.
69, my lord. Annexure P5.
Where are you saying?
The details of outward supplied, my lord. That their allegation its supply is 56.11 lakhs. That I have shown. Later I have received the bill and shown in this return and paid the tax by self calculation 12% at the rate of 12%.
That is 3,36,668.
Each act.
So now they are calculating at 10 lakhs.
No, my lord. 10 lakhs is tax, and as per adjudication order, my lord, 10 lakh.
No. As according to them, you have paid 336.
Yes.
They have calculated 505.
At the rate of 18%.
18%. 10 lakhs, 10,000.
But this point, whether rate of tax that can be adjudicated by
That was not adjudicated because
He didn't reply.
he did not come up with any paper showing that he's a government
but
contractor.
that you have to
Unregistered supplier, it is 18%. Had it been the case that he had come up with the papers that he has supplied it to the government, then it will be 12%.
My lord,
so how much was that 10%?
10%, my lord, 1 lakh 1,000. 1,01,000 already paid, my lord, 10%.
As a pre-deposit, he has paid like 10%. But the total demand is tax is 10 lakhs.
10,000.
And then interest is around 1,45,000. Then penalty is again 10 lakhs.
So another 2 lakhs you pay. We'll send it back to the assessing house.
My lord, subject to correction, my lord, 1 lakh, because I am a small contractor, my lord. I am very small contractor, my lord.
And government contractor.
Government contractor.
And government will not pay.
Yes, my lord, that's a problem. That's
100%.
But that I am not normal.
I
But
will give you records. I will give you records that they don't pay. So as a result, what they do is, especially if it is labor contract, manpower supply, let us assume you are fixing minimum wages being revised once in 6 months. Let us assume daily wages is 400 rupees, 300 or 400 rupees. He will pay only 250. The remaining he will retain contractor because you are not paying him. Arrears is there. So from their salary, he will take.
But
He will
I
sustain.
I do not know, my lord, whether he is a central government supplier or a
No, no,
state
no,
government.
state
supplier.
government.
I do not know.
Additional commission, Jalapur.
Because he comes
1 lakh.
1 lakh.
because this
Because I will
petition, my
pay
lord,
interest.
it was at the interim stage. He has come up before this honorable court on flimsy grounds.
Bank attachment,
That
my lord, remove,
there is
my
no digital signature. All these flimsy grounds, my
That
lord.
is all
It was
you-
not communicated through.
That is all invention of Himanshu and not disclaimed. This intra-court appeal is directed against the order passed by the learned single bench dated so and so, refusing to grant any interim order. While entertaining the writ petition challenging an order passed by the appellate authority, rejecting the appeal filed by the appellant as against the demand of tax on the ground of limitation. At the request of the learned advocates on either side, the writ petition itself is taken up for hearing along with this appeal. Certain facts are not in dispute. Show cause notice was issued on 22/9/2021, stating that the there is short payment of tax, and the assessee was directed to produce supporting documents as evidence in support of their claim on the date mentioned in the show cause notice. According to the assessee, the assessee did not reply to the show cause notice, nor produce any documents. The excuse given by the assessee is not acceptable. On account of this, an order was passed on 26/11/2021, determining the tax liability and under both the central and the state act. According to the state act, and after the assessee's bank account was attached, the appeal was preferred by the assessee before the Senior Joint Commission of Revenue, Commercial Taxes, Siliguri Circle. There was a delay of 297 days in filing the appeal. After extending the benefit of the order passed by the Honorable Supreme Court, yet there was a delay of 114 days. Obviously, the appellate authority is not empowered to condone the delay beyond a period of 3 months, as there is a statutory embargo in terms of section 107 within bracket 1 of the GST Act 2017. Therefore, the order and therefore the appeal was rightly dismissed. In this situation, it has to be seen as to what remedy the assessee would be entitled to. What we note is that the assessee had already paid tax at the rate of 12% on the ground that he is a government contractor. But the demand has been raised by computing the tax at 18%. For the reason that the assessee did not produce any document before the assessing officer to establish that he was a registered government contractor. The assessee having paid at the rate of 12% at the time of filing returns and also paid the 10% of the disputed tax as pre-deposit during filing, pre-deposit at the time of filing the appeal. We are of the view that one more opportunity can be granted to the assessee to produce proof to show that he is a registered government contractor. However, this opportunity shall be subject to condition. In the result, the appeal and the writ petition are disposed of by setting aside the orders passed by the appellate authority and remanding the matter back to the original authority. And the original authority, namely the Assistant Commissioner, SGST, Siliguri Charge, Siliguri, shall afford an opportunity of remanded back to so-and-so authority with a condition that the appellant shall pay a further sum of rupees 1 lakh. And upon such payment, the said assessing officer shall consider the documents which the assessee may produce and examine as to whether the assessee was right in computing the tax at 12%. And after considering all the documents and affording an opportunity of persuading to the assessee, the assessing officer is directed to pass fresh orders on merits and in accordance with law. If the assessee fails to comply with the condition, above condition within the time stipulated, the benefit of this order will not inure in favor of the assessee, and the appeal will stand automatically dismissed without reference to this court.
My lord, bank attachment may be lifted, my lord.
If the assessee complies with the above condition within a period of 2 weeks from the date of receipt of the server copy of this order, the attachment of the assessee's bank account shall be lifted.
I'm grateful.
Next.
I don't know, 6.
Yes.
Please, my lords. I'm appearing for the appellant.
Before my learned friend starts, my lord, there are 4 analogous petitions heard by my lord single judge. One of them I appeared, my lord. That has not been my lord appealed against, my lord. And both 4 of them, my lord, the 4 writ petitions affirmed by one person. That is the clandestine, my lord, here, my lord. They, my lord, we have shown the clandestine before the learned trial judge, my lord.
My lord, I'll indicate the facts before your lordships. Lord, we have come up in appeal in one matter where, my lord, I am appearing in those.
Test case, is it?
Lord,
it's a test case.
No, my lord, I'm only briefed in one. Over there also, my lord, I'm briefed only in one matter.
No. What do you say about this allegation? 4 writ petitions affirmed by the same person in respect of 4 different bank accounts or one?
No. There are 4 entities.
No.
4 entities?
I have taken the instruction. No, it is not.
Analogous hearing was
analogous because of this reason, my lord. The issue here, why, my lord, we are before your lordship is because, my lord, the interim order was refused. Now, my lord, the interim order was refused. I have only two broad points, my lord. One is the point of, my lord,
what was the order impugned in the writ petition?
It's the order which is annexed with the memorandum. Your lordship will find the order dated 13th of April 2023. The order impugned in the writ petition is, my lord, attachment of bank accounts of a firm. My lord, I am appearing.
No, if stay is granted, then your writ petition is allowed. That can't be granted.
My lord, the difficulty
He can advance the date for filing the short affidavit or whatever it is. Within a week, he will file it, and that has been. I will ask the writ petition to be listed. Suppose he is able to. We are now on.
By next Friday, we will file the affidavit, my lord.
We will list the writ petition on 10th May. That can be done. This intra-court appeal by the writ petition is directed against the order refusing to grant interim order. The learned single bench was perfectly right in refusing to grant an interim order, since the effect of granting the interim order would be virtually allowing the writ petition at the interlocutory stage, which is impermissible under law. However, since the learned advocate for the appellant submits that the appellant is suffering on account of attachment of his bank account, we are of the view that the hearing of the writ petition can be advanced. Accordingly, while dismissing the appeal, we direct the respondents to file their affidavit in opposition to the writ petition on or before 4th May 2023, and the writ petition may be listed before the appropriate learned single bench on 10th May 2023 with a request to the learned single bench to consider this on merits.
I'm deeply obliged, my lord.
Yes, sir.
I'm good.
Next.
Item number 7.
Lord, item number 7, I have a preliminary objection with regard to maintainability of this repetition, this appeal.
Appeal.
Lord, this appeal is not maintainable under clause 15 of the latest patent act. The interim order has been granted in favor of the.
No, interim order has not been granted.
Lord, should my kindly looks at the impugned order.
Shall not be encashed.
Encashed.
My lord, first part, my lord, kindly have a look at it, that
No scope for passing
passing
it.
any interim order.
But it has been granted.
No.
That
Only
The bank guarantee furnished by the petitioner
No,
for release of vehicles in question shall not be encashed by the respondents.
probably interim order was for a larger relief.
Interim order in the nature of a final, in the nature of a final order.
So, my lord, may I submit your lordship for 2 minutes? But the issue
Interim
involved, your
relief,
lordship,
interim relief in terms of the prayers above. That means interim.
It is akin to the.
What was the writ petition for?
my lord,
Appellate order dated 9/11. What is 9/11 order?
my lord, 9/11 order, my
Page
lord, is on
99.
page 97 onwards, your lordship.
99 in fact. The reason order.
Assistant communicator also. I think they can adopt a much more smaller font. Requires a magnifying.
It is very small. My learned friend could have
I should have submitted a typed copy.
typed
my lord.
copy, my
No,
lord.
typed copy, 100 mistakes will be there. Issue is e-wayable.
My lord, the identical issue has already been dealt by your lordship in a matter room ki Vishwas, your lordship, where I could not generate the part B of the e-waybill, which is unintentional, your lordship. And part, my lord, I explain, your lordship, what is contained in part A and part B of the e-waybill. Part A contains all the details with respect to consignor, consignee, invoice number, value of the goods, tax amount involved, everything. My lord, only thing which is required to be filled up in part B is relating to the transporter detail, because that is at the time the consignment moves, then the transporter detail and the consignment details are captured in part B, then only it becomes a complete e-waybill. But my lord, in my case, the goods were destined for export and there is no dispute. My lord, the physical verification report is on page 60A. Page 60A, my lord, kindly have a look at it. Page 60A. My lord, this is a physical verification record, description of goods as per invoice. My lord, it is mentioned description of goods in the conveyance, then quantity as per invoice, quantity as per physical verification. So discrepancy is nil. There is no discrepancy whatsoever with respect to the goods I was carrying as per invoice, as per the physical verification report, as per my e-waybill also, in fact. So there was no discrepancy, and in fact the goods were exported also, and all the evidence with respect to all the export documents, they are on page 47 to 58, which, my lord, it even includes the.
That is not disputed.
That is not disputed.
What is the dispute?
My lord, the dispute is that I could not fill up the part B of the e-waybill, and in fact I made a specific submission that there is no intent to evade, but the learned appellate authority dealt with that.
No. What did the original authority do? Page 65.
The original authority is, my lord, the passed the order on page 69. Page 63 onwards.
64, my lord. It is 64 to 66.
63 onwards.
Reason order is 64.
My lord, that is not very legible, so I am submitting this copy, my lord. This is a better.
What was the allegation? Part B was.
Part B is not. That is the allegation.
Part B was not at all filled up, is it?
Not at all filled up. So that is
not
undisputed,
generated.
your lords.
Not generated.
Not generated. So that is
So
not.
That is why That
The
is why-
goods were transported without valid documents.
Without, my lord, the part B, my lord. So to that extent, there is no dispute, my lord, with respect to the fact that there was a default on my part in not filling up the part B. But the question, my lord, I ask myself is then which has been dealt by almost all the high courts, including your lordship, and there is a judgment of the Allahabad High Court also. There is a judgment of Supreme Court also, that unless the intent to evade is there, just because I have defaulted on some procedural irregularities with respect to my transportation, my lord, this 200 penalty under section 129 should not be imposed. My lord, I rely upon one of your lordship judgment and one judgment of your lordship, the one Allahabad High Court judgment dealing with the identical issue, your lordship.
Satyam Shivam,
My lord, kindly refer to
city card.
Page 9.
my lord, page 9 onwards. This is the Allahabad High Court judgment. My lord, on page 10, your lordship, kindly refer to the last 3 paragraphs. In the present case, prima facie, no intent to evade the duty can be ascertained only on the allegation that the part B of the e-way bill was not filled. More so in view of the fact that the vehicle in which the goods were being transported on a Delhi number, the said goods being decided in the judgment dated so and so in the case of so and so, covers the issue raised in the present case also. As such, for the reasoning recorded above, the impugned order so and so and appellate order so and so are set aside. So, my lord, the identical case. Then, my lord, your lordship judgment, page 12 to 17. My lord, kindly refer to paragraph 7 onwards, page 14 of the compilation. Paragraph 7. The case of the appellant is that they had generated part A of the e-way bill on 22nd March 2022 and part B was generated on 24th March 22. However, since the goods could not be loaded into the vehicle, the appellant appears to have cancelled part A of the e-way bill dated so and so and generated new part A e-way bill on 24th March. When the vehicle was intercepted, the driver was carrying part B of the e-way bill in respect of which part A has been cancelled. The question would be whether this would tantamount to intention to evade payment of duty or with a view to clandestinely move certain goods. In our prima facie view, it does not appear to be so and could be considered to be a bona fide error. So, my lord, in that case, what happened is that I generated one e-way bill and I cancelled it. Then second e-way bill I generated, but I did not generate part B. So, the identical fact, your lordship, and there also.
No, here your reply was that due to clerical error,
Yes, your lordship.
e-way bill part B
was not generated.
was not filed.
Yes,
There
your
was no part B at all.
Yes, your lordship.
That was a case where there was originally a part B, etc.
Yes. That. So some difference of fact is there, but the eventually in that case, what happened is there also I could not fill up the e-way bill which part A which I was carrying, part B was not there. That is a fact.
What the authority says, if you have not generated part B,
yes,
part A is an invalid document.
That is, my lord. That is their
now they impose 200%, is it?
And it involves 200% duty when, my lord, the export of the goods.
Sir,
and
actually,
it is not liable to tax also.
It is revenue neutral.
It is revenue, no doubt about that. But this case, the facts of this case is entirely different from all the other case. Here in this case, the vehicle had plied around 1400 kilometers.
Without documents.
Without document, without. And my learned friends.
But the fact remains that the goods were meant. The goods have been exported. So it's revenue neutral. When there is no tax payable, why do you flog him with such 200%?
200% of the tax.
His contention before the appellate authority is that the requirement of generating this e-way bill is procedural in nature. I will not carry.
That is wrong. That is wrong.
And he has relied upon around 10 to 12 judgments before the appellate authority.
Something, my lord,
saying that this is procedural.
My lord, I may have relied upon
precisely for that reason the appellate order, which is exhaustive order, was passed. My lord, at the outset I was on the point with regard to maintainability of this writ petition. My lord, he had relied upon around 10 to 12 judgments before the appellate authority. The appellate authority rejected his appeal on the ground that it was required. And the vehicle had plied around.
It is mandatory.
Mandatory. It is
that we'll hold. It is mandatory. Part A and B only. They have to carry both. Part B is missing. Part A becomes invalid.
Invalid.
So therefore, in effect, it was a transportation without
Valid documents.
for 1,400 kilometers.
1,400 kilometers. Grateful to you.
But ultimately, the goods were exported, which position is not been disputed with revenue, and it has become revenue neutral. In this facts and circumstances, should he be penalized for, and he gave some lame excuse saying that clerical mistake, etc.
But that is why, my lord, section 122 is there.
And what will be the correct penalty?
My lord?
What will be the appropriate penalty according?
My lord, according to me, my lord, section 122 can be invoked in this particular case.
10,000.
My lord, 10,000 rupees, my lord. Because, my lord,
What was the value of the goods?
my lord, the value of the goods was,
Where is the?
my lord, part A, page 44.
Nine crore
Nine-
six.
9 crore 66 lakh 96 lakh 67,885.
Oh, 96 lakhs.
96
And what
lakh.
were the goods?
My lord, the goods were
Slide fasteners.
Slide fasteners, part of zippers,
Zipper
etc.
parts. Slider. To Bangladesh.
my lord, is Bangladesh. All the documents are from page 45 onwards. And including there is a statement of bank realization also on page 57 from Director General of Foreign Trade. This bank realization certificate is also there. The payment has also been received in my lord, foreign currency.
In fact, page 44 itself says not valid for movement as part B is not entered.
And the face.
1584 kilometers.
Yes, your lordship, that is correct.
So how much is the penalty imposed?
Well, penalty imposed is 200%, my lord.
How much? How much? Quantum?
My lord, kindly refer to page
2,32,000. No, 23 lakhs.
23 lakhs, 20,000.
My goodness.
That is how the law is, my lord. It is for both the CGST component as well as the SGST components. 11 lakhs for CGST authorities, 11 lakhs for
It's a
SGST.
very huge sum, sir. 23.
That,
When no tax was payable.
and 129, my lord.
That is why, my lord, 122 can be invoked in this particular case. Kindly, my lord, kindly have a look at
122, my lord.
No, 122 can't be because it is an transportation without documents.
Without valid, it says without proper documents.
Let him file his affidavit in opposition.
That transports any taxable
And he has
goods
already
without the
obtained
cover of
release of the goods and the conveyance by paying the penalty.
My lord, what it says, my lord,
by giving
transports any
By
taxable.
furnishing the bond and the bank guarantee has obtained release of the goods and the vehicle.
How much bank guarantee here?
My lord,
My lord, the bank guarantee is for the
Entire
amount of the tax.
Entire amount.
Entire amount of
and
the
we have
tax.
been directed not to encash that bank guarantee. The interim order in his favor.
That interim order will continue. You file your affidavit in opposition, the writ petition within 2 weeks.
My lord, my submission is that similar cases, your lordship, my lord, maybe
This is very unique case. This is without valid document. See, your part B has to be generated, no? Part B, if you part B is not generated, part A is an invalid document.
my lord, that I understand, my lord, but what I say is that section 122.
All right, no, you exhaust that and come. This intra-court appeal by the writ petition is directed against an order dated 20th January 2023 passed by the learned single bench in WPA 1166 of 2023. In the said order, there has been one portion of the order passed by the learned single bench is in favor of the appellant, whereby the respondents have been directed not to encash the bank guarantee which was furnished by the appellant as condition precedent for release of the vehicle in question. The prayer sought for by the writ petitioner was to stay the order passed by the original authority as well as the appellate authority, levying 200% penalty on the ground that the goods were transported without proper documents. If such a prayer is acceded to, it would amount to allowing the writ petition at an interlocutory stage, which is not permissible under law. Therefore, the learned single bench was right in not granting the interim order sought for, as it would amount to allowing the writ petition. Hence, we are not inclined to interfere with the order passed by the learned single bench. However, taking note of the fact that the bank guarantee of for a sum of rupees more than 28 lakhs has already been furnished, and that that the goods were meant for export, and it is a case of it's a revenue neutral case, the writ petition could be heard at an early date. Therefore, we dispose of this appeal by directing the respondents to file their affidavit in opposition within 12th May 2023, and the writ petition be listed before the appropriate bench on 18th May 2023, with a request to the honorable bench to take up the said writ petition. Next.
Item number 8.
I beg to appear for the appellant. My lord, learned single judge, my lord. In this,
I have no copy of the appeal, my lord, as on today. I verbally request him to serve a copy because of the program going on Ministry of Law and the Ministry of Finance.
Yes.
I'll submit.
And what happened? Writ petition dismissed.
Yes, my lord. Dismissed and gave liberty to file, because after 148 AD order, the procedure continues. I have during the pendency of writ petition, they issued show cause notice, gave 2.5 days time, and we have also requested for personal hearing. That also not given. Final order 147 passed, my lord. And we are challenging 148 AD also and 147 also.
Well, during pendency of the writ petition, what I understand, my lord, the assessment order was passed, which is an appealable order.
In fact, in the previous matter where you are here, no, where Mr. Kaitan and Mr. Om Narayan Rai appeared, that is also a case where
yes.
147 was passed.
Yes.
Reassessment order was passed.
Yes, my lord.
We have allowed that writ petition. You served?
Yes, my lord. I will serve, my lord, after photocopy. During.
Then it will come next week.
Next week,
my lord, kindly keep it on Tuesday.
Tuesday, Friday, only.
Friday.
But Friday is a holiday, no?
Holiday.
Friday is a holiday.
Friday.
What is Friday? Huh? Tuesday. What holiday?
Fifth.
Is holiday.
Friday is 5th.
Buddha Purnima. Then 4th we can take? No. 4th we will take. Because on 4th you give some group 4 also. You mix it. The learned advocate for the appellant is directed to serve papers on Mr. Samrajit Roy Chaudhary, learned standing counsel with the respondent. List the matter for admission on 4th May.
4th May. I'm grateful.
Next.
Item number 9.
Lordship, 9 I appear for the petition. Lordship, the single judge's order is at page 20, wherein my writ was dismissed on the ground that the order in original which I had challenged is a detailed 65-page order. That is the order, Lordship. Lordship, the issue is a very narrow compass. My detailed manual scrutiny under service tax provisions was conducted by my division office in 2018. I had replied for the entire period from 12-13 to 17-18. Then, Lordship, in detailed manual scrutiny,
why did you file a writ petition challenging that?
Lordship, because of jurisdiction, extended period of limitation cannot be invoked subsequently.
That's not a pure question of law.
Lordship, the question of law which was raised in the show cause reply also, the learned adjudicating authority has not dealt with my submissions at all. In fact, he has not taken into account my submission of 30th January.
All grounds you raise in the appeal.
Yes. Lordship, adjudicating authority, I'll just show you 2 pages, Lordship. Just 2 pages, Lordship, kindly come to page.
No, no, no.
Lordship, on the extended period, he has not given any observation.
Very good case. You will 100% succeed.
Lordship, kindly come to
Before the
page.
trial.
Lordship, kindly allow me 2 minutes, Lordship, to submit. I'll show you through documents and your Lordship may decide.
Please.
Lordship, kindly come to page 200.
200.
200. Lordship.
Yes.
This is the order in original, and this is the discussion on the applicability of extended period of limitation by the adjudicating authority. Lordship, para 4.8.1 to para 8.4. Lordship, now if I compare this with page 88. Para 7.1, which is show cause notice. 7.1 to 7.3. It is exactly the same. Now, Lordship, in the order, he takes into account my submissions on extended period, which is at page number 177. Page 177, Lordship. Extended period of limitation cannot be invoked. This is from my reply, which he has dealt with. All these are from my reply, whatever the judgments I have relied. He has copy pasted every judgment. But what he has given in the order, Lordship, what was the allegation in show cause? This is my first contention, Lordship, on the extended period. Second, Lordship, kindly come to, Lordship, page number para 4.1, page 188, 185. Discussion and finding, where the order discussion and finding starts. Lordship, I'll read thereafter, Lordship, 9th line. Thereafter, HNPL wide letter dated 10/1/23 submitted their written submission, which I consider as their final submission. 10/1/23. That date is there, Lordship. Para 4.1.
Then what else you
Lordship, Lordship, kindly come to page 97. 97, Lordship, is my acknowledgement dated 31 January 23, and 98 is my cover letter, wherein I have written, this is with reference to our earlier submission dated 10 January. It is stated that due to mistakes on the part of accountant, we have not submitted certain useful necessary documents, which we are submitting now.
Yes,
Not considered. Plus, Lordship, my last contention, Lordship. Lordship, kindly come to page 62A.
Yes.
62 was not a fair copy, Lordship, therefore 62A. This notice was issued to me in 2018, Lordship. It's a typed copy, wherein from October to from 12/13, October, March 12/13.
Yes.
October, March 12/13 to April to June 17/18. My entire service tax detailed manual scrutiny was conducted. They said these are your payables, you have not paid. I had replied to it on page 68. My reply is there on 31/8/2018. Now, Lordship, kindly come to page 205.
Yes.
This is a board instruction dated 36/15 regarding detailed manual scrutiny. What one checks in detailed manual scrutiny? What is the responsibility of the department to verify? Lordship, kindly take up page 206, para 5.2. I read, Lordship, para 5.2. One of the important objectives of return scrutiny is to ensure validation of information furnished in the self-assessed HT3 return. The validation exercise would require reconciling information furnished in HT3 with ITR 456 and 20 AS and third-party information made available. In addition to this, the scrutiny must look into the correctness of self-assessment with respect to taxability, admissibility, valuation, and Senvec data weight. This is what board says. Now, Lordship, kindly come to the show cause at page 71. Lordship, kindly come to show cause. I just want to show one more. What is the basis of this proceedings? Page 71. Page 72, Lordship. Page 71 is the investigator, page 72, para 2.2. On analysis of submitted statements of P&L income tax 26 years vis-a-vis ST3. This is what the allegation was made. This show was issued in 21. Already 2018, my DMS has been done. All records are with the department. Today, 21, they come, they again verify it. They say, we will invoke extended period. Lordship, the basic issue of jurisdiction. Lordship, let this be pending before your lordships. Because if the lower effort.
What order we will pass, we will decide.
Lord,
You don't say what order.
Lordship, I apologize, Lordship. I apologize, Lordship.
We'll consider. Please come. This intra-court appeal by the writ petitioner is directed against the order passed by the learned single bench dismissing the writ petition on the ground that the order impugned to the writ petition was a speaking order. What was challenged before the learned writ court is an order in original dated 7th February 2023, passed by the Commission of Central Tax within brackets GST and CEX, Haldia Commissionerate. Admittedly, the order impugned to the writ petition was an appealable order. Under section 35 capital B of the Central Excise Act 1944, read with section 174, section 174 within bracket 2 of the CGST Act 2017, and such appeal would lie before the Customs, Excise and Service Tax Appellate Tribunal, New Delhi. The learned advocate for the appellant would vehemently contend that the preliminary objection raised by the appellant in the reply to the show cause notice with regard to invocation of the extended period of limitation has not been dealt with by the adjudicating authority. And in this regard, the learned advocate elaborately referred to the submissions made by the assessee before the adjudicating authority and sought to demonstrate that the adjudicating authority, though has extracted the submissions in its entirety, along with the decisions which were relied upon, no finding has been recorded as to the correctness of invoking the extended period of limitation. To strengthen the said submission, paragraph 4.8 of the adjudication order dated 7th February 2023 was referred to. It is further submitted that all other factual details were fully explained, and if there is and if the department has to resort to detailed manual scrutiny of the service tax returns, it is required to follow the directions issued by the board in circular number 185/4/2015-ST dated 30/6/2015, more particularly para 5.2 of the said circular, which has not been followed in the by the department. Apart from that, various other issues were also pointed out with regard to the allegation in the show cause notice and as to what is the nature of reply given by the assessee, etc. Our attention was also drawn to the communication sent by the superintendent, CGST and CX, dated 17/8/2018. We have heard the submissions of the learned senior standing counsel for the respondents. Admittedly, the grounds which have been canvassed before us in this appeal as well as in the writ petition are not pure questions of law, but mixed questions of fact and law. Whether the reasoning given by the adjudicating authority while considering the issue relating to invoking extended period of limitation is sufficient or not in the facts and circumstances cannot be adjudicated by way of affidavits in a writ petition. Apart from that, the power given to the tribunal under section 35 capital B of the Act is wide enough to re-examine the factual position, and the tribunal, being the last fact-finding authority, can call for records, examine all details and take a decision in the matter. Therefore, we are of the view that when such an effective and efficacious alternate remedy is available under the Act, the petitioner should, the appellant should not be allowed to bypass such remedy on the bypass such remedy, more particularly on the grounds which have been canvassed in the writ petition. Therefore, we are of the view that the writ petitioner should, we are of the view that the appellant should avail the alternate remedy under the Act. Accordingly, the appeal is dismissed, giving liberty to the appellant to challenge the order dated 7/2/2023 before the learned tribunal. The period during which the writ petition was filed till receipt of the survey copy of the writ petition was filed till the until the receipt of the server copy of this order shall be excluded for the purpose of computing limitation while filing the appeal. Since the appellant if the appellant chooses to avail such appellate remedy, then the learned tribunal shall grant 15 more days time from the date of receipt of the server copy of this order while computing limitation. With the above observation, appeal is dismissed.
Kindly.
One more matter you come, item 10.
So that we can take under
Item 10.
Item number 10.
we can do it now or fourth. We can do it on fourth, Lordship.
All right. At the request of the learned counsel for appellant on 4th May.
Kindly before your Lordship rises.
No, one second. What is this adjourned matter, sir?
No.
Item 11.
No, something else.
Item 11.
Not only. I was
Under
seeking-
compelling circumstances, may I indicate, Milord, writ petition is moved today, Milord, for alleging denial of permission by the police authorities for holding a rally. In Khidirpur tomorrow, Milord. Milord, in Khidirpur area. Milord, state comes up with a submission that we are not denying the rally. The place, two of the points of the proposed rally, Milord, are preoccupied. So these 2 points, Milord, I have marked, Milord. Milord, the state comes up with this stand that it is only the last 2 points that are preoccupied. So please hold the rally. We are not denying you. Kindly do not attain these 2 points. Lord, learned First Court has directed the holding of the rally. Milord, I vehemently requested the Honorable First Court to not, Milord, police is apprehending today, Milord, a law and order situation. The area is of Khidirpur, Milord. Little, Milord, with all humbleness, Milord, I must admit, a little volatile place, Milord. We have, Milord, our apprehensions. The police authorities apprehend there might be a law and order problem if both both are, Milord, political parties. Milord, I must admit before your Lordship. Well, both are loggerheads with each other. So all, Milord,
friend is there, Sirjit is there.
No, Milord, he did not appear, Milord. What I was humbly praying, Milord.
I thought, Milord, that he is mentioning the next matter. There also a permission is granted. Now, Mr. Subhish Sannal was appearing in this matter.
What I was very humbly, Milord.
One thing, whatever it is, but if suppose, where is the advocate?
Milord, I will put him on notice. My Lord, may kindly fix the matter at 3 p.m. Milord, I'll come with a memo.
3 p.m. there is another division.
Whatever, 2:30, Milord, I'll put him on notice, Milord. Just now the order has been passed, Milord. I have come running to your Lordship, Milord.
No, whether the order has been uploaded.
Milord, I have prayed before the learned First Court, Milord. The First Court has Milord, assured that the order will be uploaded. Milord, will kindly appreciate my difficulty. Milord, being the police authorities, Milord, I have apprehensions that a law and order problem might happen. Milord, that is my specific stand in the report filed before the Honorable First Court. Milord, tomorrow is the rally. If something, Milord, your Lordship has evinced the happenings of wrong things, unwanted incidents during such rallies, Milord, my Lord will kindly do something about it. My Lord will kindly call for the writ file.
No, you can always seek for review of the order by.
Milord, tomorrow is the rally, and I have very earnestly requested the First Court that I do not.
Without the copy of the order, we cannot allow you to file the appeal.
subject to my lord, what falls from the bench, my lord.
No, what you do is you bring the petitioner's advocate in the afternoon.
2:30, my lord, I'll bring.
And I
What I was, 2 p.m.
I was seeking a similar leave, my lord. The order is uploaded. It was passed yesterday. And I was seeking your lordship's leave, my lord. The matter is extremely urgent, my lord. The cause of action is, my lord, on Monday. My lord, the learned judge has declined to grant me relief, my lord, yesterday. The matter,
What is the relief?
the relief is, my lord, I am intending to conduct a fair, my lord, of Mela on.
Yes, your
my
junior
lord,
counsel.
kindly, my lord, kindly give me leave to file the appeal without.
File the appeal, it won't be no urgency on that. Mela fair can come one day later, sir.
My lord,
There are so many issues. People are not being paid wages.
My lord, may it
People
appear,
are,
may it appear
on-
on Monday.
yeah, all fair. It won't come on Monday. What is the urgency?
My lord, the urgency is, my lord, the committee of the college has restricted the area which was, my lord, it belongs to their land. My lord, the previous division bench order is also there.
In a college ground, you shall not conduct.
My lord, if that is so, that is so. But the college has said, yes, you conduct it.
We will pass such an order.
My lord, previous year, my lord, the college, my lord, wanted to restrict. The
Yeah, every-
municipality wanted to restrict. The college said it is our ground, we shall give permission.
Yes, we will say that college ground should not be utilized for a mela.
My lord,
It's
kindly,
against public interest. It's against the interest of.
my lord, kindly let the matter appear on Monday, subject to your lordship's convenience.
There's no urgency. You file it in the department. Let us.
My lord, with the leave is required, my lord, without the certified copy.
No, with the certificate. May I take back the? Mela can wait, sir. Sir, there are a lot of
My lord,
priorities.
yesterday the matter was uploaded. Let me take my chance and lose, my lord, before your lordship.
No. Why, you will win before us.
Maybe, my lord, kindly let the
We
matter,
think
my lord,
positive.
at least this leave be granted.
Sorry.
As your lord.
Congratulations.
24th of this month.
Very good.
This is appellate side matter, my lord. Now, my lord, there is a printing mistake. Minor printing mistake, my lord. Your lordship directed the commissioner of Risra municipality to take necessary action as per our according to our complaint. Now, my lord, instead of commissioner, it will be, my lord, the chairman, because in Risra, my lord, this is there is no commissioner. So, my lord, let this matter may be listed, my lord. in
Can
the
we
list
show?
for necessary.
Huh? But how they will take? Huh?
I have annexed the order, last order of your lordship, my lord.
Only in para 7 it has.
Only para 7, my lord, your lordship kindly see, my lord. Instead of commissioner,
This matter
it will be the chairman.
been listed in the supplementary list under the caption to be mentioned. It is pointed out by the learned advocate for the petitioner that in paragraph 7 in 2 places, direction has been issued to the commissioner of the municipality. It is stated that insofar as Rishra municipality is concerned, it is not there is no commissioner, but the appropriate authority is the chairman. Accordingly, in paragraph 7, wherever it is stated as commissioner of the municipality, it shall be mentioned as the chairman of the municipality. This order shall form part of the order dated 24/4/2023 and necessary correction be effected.
It will be, my lord, chairman.
Correct.
Chairman, DPW.
Under compelling circumstances, may I be permitted to mention a matter, my lord? This is regarding my lord knows there was a brutal rape, my lord.
Single morning itself, 2 or 3 people have mentioned. We have said there is no urgency. Single bench is already dealing.
But in this case, my lord, what has happened just day before yesterday.
What do you want us to do now?
The public interest litigation has been filed in regard
Yeah,
the police has shot down a person, my lord. If
it will come in the list, please.
my lord will kindly list it on Monday. That is all.
That we will decide depending upon what has to be done.
My lord will my lord, I was humbly praying for CRPF protection of that family, my lord. The police has shot down that person.
Yes.
If it is not listed, my lord,
that family members can approach the single bench.
but my lord, that those family members may not be financially well enough and not.
It up as a pro bono matter.
This is a public interest litigation. This is being
take
filed.
up as a pro bono matter. Do it for the family member.
May I be permitted to mention, my lord, upon notice, I am mentioning a hearing matter for inclusion in the list, my lord.
Which year?
It's 2018, my lord. It's
It's not running in the.
No, my lord.
I don't know, sir, whether only one day we are able to take up.
And if it could be at least included in
You
the
give
list,
the
my
slip letter, we can't assure you anything.
May I have a lordship's kind leave to mention a very typical procedural issue which has arisen in regarding preferring appeal against an order passed by the authority for advance ruling under the Customs Act. Now section 28 KA stands amended and the appeal has to be preferred before the Honorable High Court, the jurisdictional High Court. Our rules, the High Court rules, do not provide for any specific code or any specific classification preferring appeal against an order made by the authority for advance ruling. So, either this appeal, it is revenues appeal basically. They have requested me to mention the matter. Either this appeal has to be treated as an appeal with the heading casta as usual, or my lord, I am told that Delhi High Court has devised a new procedure for preferring appeal against the order passed by the authority for advance ruling. It's a section 28 KA.
Amending the rule will take some time.
But in the meantime,
what I suggest is the council can make a small note.
Yes.
To the registry.
Yes.
Saying that whatever senior has now mentioned.
The registry won't accept it, my lord.
No.
Yes, I'm so sorry.
So let him, once the note is prepared, ask them to give it to the SU.
Absolutely. Grateful.
Lord, may I mention this matter for correction of the order, my lord, passed day before yesterday in that black money matter. The 2 matters were there. In this matter, there is a correction with regard to the complaint number. And Mr. Datta is here for the other side. But I made corrections in hand.
All right. This matter has been shown in the supplementary list under the caption to be mentioned. It is pointed out by the learned advocate appearing for the appellant that in page 2, in the extracted portion in italics, certain typographical mistake has occurred with regard to the complaint case number. Accordingly, the mistake is rectified and the correct complaint case number shall be mentioned as inverted comma complaint case bearing number C, capital C /2811/2018 filed in the court of the learned Chief Judicial Magistrate at Alipur, and the complaint case bearing number CS/32076 of 2022 within bracket filed in the court of the learned Chief Metropolitan Magistrate at Calcutta, bracket close, comma, pending disposal of this application. The above quoted portion shall be substituted in page 2 of the order dated 26th April 2023, and this order shall form part of the order dated 26th April 2023, and necessary corrections be effected.
I'm grateful, madam. Obliged.
Number one, I am appearing on behalf of respondent number 4.
I appear on behalf of the appellant.
I am appearing on behalf of state.
Ask her to switch on the mic. Ask her to stop.
Item number 1 and 2.
তোমাদের নাম অনিরুদ্ধের নাম আর কে কে ছিল সব দিয়ে দেবে।
Then what happened? Live stream.
রাজেশ ওরা থাকলে ওরা যেটা করবে করে নাহলে নট করে।
Thus, at several stages of the matter, the writ petitioner did not diligently prosecute the matter, rather having been fully aware of his rights as embarked upon an exercise by filing the application before the Honorable Supreme Court, and thereafter the writ petition under Article 32 of the Constitution, and after the dismissal of the said writ petition by a recent order, after 2 years the present writ petition was filed. The posting orders of the 16 district judges were issued on 28th October 2009, and the writ petition now seeks to dislodge the said selection at this juncture, and by then, from such of those candidates who are recruited as district judges entry level, several of the candidates are now the Honorable Judges of the High Court at Calcutta. Thus, the present attempt of the writ petitioner cannot be entertained, as the writ petition is not only a stale claim, the writ petitioner is stopped from filing the present writ petition on the very same cause of action after being unsuccessful before the Honorable Supreme Court. Writ petition having been fully aware that those candidates were permitted to attend the Viva OC and personality test, and after having the knowledge of the same and having participated in selection process, is deemed to have waived all his alleged rights to question the selection. That apart, the writ petition is also hit by the principles of res judicata. With regard to the merits of the selection process, we find the selection board acted wholly within the jurisdiction. The decision taken is evident from the minutes of the meeting recorded, which cannot be stated to be minutes without reasons. The decision of selection board was approved by the Honorable Full Court, and thereafter the list of selected candidates was published and posting orders were issued. In such circumstances, had the learned writ court decided the maintainability issue as a preliminary issue, ultimately, which was held against the writ petitioner, no occasion would have arisen for making any observations on the manner in which the selection board had conducted its proceedings. We are in agreement to the learned writ court in dismissing the writ petition on the ground of delay and laches. Apart from our view that it is a stale claim, the appellant had waived what little rights he would have had, and the writ petition is hit by the principle of estoppel and res judicata. That apart, we have already held that the decision of the selection board, as approved by the Honorable Full Court, as being well within its jurisdiction. And cannot be termed to suffer from any vice of lack of jurisdiction. Therefore, all observation made by the learned writ court on the manner in which the selection board had proceeded needs to be eschewed and accordingly eschewed in its entirety. In the result, the appeal filed by the writ petitioner is dismissed and the cross objection is allowed. Next.
Grateful, my lords.
Yes.
Item number 3.
Or we beg to appear on behalf of the appellant petitioner.
Yes.
71 days.
41 days. Well, there is a delay of 41 days. We made an attempt to serve upon the other side. The postal it has come back with a postal remark that the addressee cannot be located at the address given. We have given the address as was provided in the order sheet in the before the learned tribunal. Therefore, Lordship, I was humbly praying if I can serve upon the learned advocate who has appeared before the learned tribunal on behalf of the respondents. From the record, it appears that Mr. Odijit Chakraborty appeared on behalf of the respondents.
That can be in addition. You do one thing. You take fresh notice. Plus, in addition, you serve the fresh notice to the respondent. And in addition, the learned standing counsel for the appellant department is permitted to serve the learned advocate who appeared for the respondent before the tribunal. List the matter after service of notice. I list the matter after filing affidavit of service.
Or do we have to also serve the petition or only a notice? Upon the learned advocate, we will furnish everything. And to the party will give a notice, my lord.
Petition.
I'm grateful to your lordship.
Item number 4. New application tax matters.
But I'm appearing for the appellant, my lord. Before your lordship takes up this matter, my lord, we the panel counsels are facing some difficulties, my lord. May I just hand it over to us? No, sorry. No.
Now the matter has been transferred to the income tax department.
Hello.
Now they have not yet drawn up a fresh panel.
No, not yet.
So they have
But they have this advertisement, my lord.
issued notice for empanelment.
Yes, yes.
Last page.
But my lord, we are empaneled by the president, my lordship. I have given that. Document. We are tenure, just 1 year has been completed, not 1 year. Our tenure was for 3 years, my lord.
Then what to do in the interregnum?
No,
You have
my
to
lord.
issue some direction.
Yeah, lordship, lordship.
That,
Yes, yes.
but who's appearing for the respondent in this item 4?
My lord, it was served, my lord. Lordship, can they have received. I have my filing.
How many days delay?
183 days, my lord.
Wait, we'll pass
Yes,
such an
yes.
order, some order where both sides are appearing.
My lord.
Item 4, we have heard Mr. Prithu Dorial and senior standing counsel for the appellant. Though notice has been served on the respondent, none appears for the respondent. The affidavit of service is taken on record. There is a delay of dash days in filing the appeal, and on perusal of the affidavit filed in support of the application, we find sufficient cause has been shown for not preferring the appeal within the period of limitation. Accordingly, application is allowed. Delay in filing the appeal is condoned. List the appeal for admission on so and so date.
My lord.
Next.
Item number 5.
Yes.
I'm appealing for the respondent.
How many days delay?
This is the delay of 1,194
Too
days.
long, Lord, and it's a Tripura Cricket Association. Normally, Lord, I don't stand in the way of delay, but Lord, this is rather too long and
Too
for
long appeal. And what is the issue?
Lord, the issue is not that with my land friends leave. Lord,
Well, BCCI has granted some subsidy to them to the tune of 54 crores. Now, while giving income tax return, neither they show there as an income or liability, nothing. So that is the issue.
It is a donation.
Lord, it was given for as infrastructure subsidy. So Lord, there are two claims for contentions were
Then
raised.
we'll do one thing, sir. You please file your affidavit in opposition. Because the amount involved is huge. So we will first.
Well, first, the delay should be condoned.
No, let them file the affidavit in opposition.
On the point of delay.
Yes.
Yes, because Lord, actually, Lord, if I may just indicate, I'll file the affidavit. Lord, the two alternative contentions were raised that in any case, I have given a form 10 for accumulation. So Lord, even if I fail on the aspect of corpus donation, in fact, corpus donation was an alternative contention. The main contention was I have filed a form 10 for accumulation. I will spend it in a later year. So Lord, that part has been accepted also. So Lord,
please take down. We have heard Mr. Samrajit Rajchakri, JP Ketan assisted by so and so. There is a delay of 1,224 days in filing the appeal. At the request of the learned advocate appearing for the respondent, time is granted for filing affidavit in opposition till 4th May. Reply, if any, by 11th May. List the matter under the same caption on 12th May. Sir, one order we will pass in.
Yes, madam.
During the course of argument, the learned senior standing counsel for the appellant, as well as the other learned standing counsels, has brought to our notice about the recent order passed by the Joint Secretary and Legal Advisor, Ministry of Law and Justice, Department of Legal Affairs, within bracket Judicial Section, Government of India, dated 9th March 2022 and 19th April 2023. By the said order, direction has been issued that all pending briefs of income tax appeals, references, writ petitions, wealth tax, gift tax, and estate duty matters, etc., will be handed over by the in-charge branch secretariat, Kolkata, to the Income Tax Department, Kolkata, within a period of 15 days from the date of receipt of the order. Further, it is stated that the panel council of the Department of the Ministry of Law and Justice for conducting income tax litigation before the High Court at Calcutta shall continue to attend the matters till a new panel of advocates is formed by the Income Tax Department / CBDT. Full stop. The Commissioner of Income Tax within bracket Judicial, Kolkata will take over all the briefs of their pending matters from the branch secretariat, Ministry of Law and Justice, Kolkata. The Principal Chief Commissioner of Income Tax, Kolkata, has been requested to take all necessary steps to form new panel of advocates in accordance with CBDT instruction number 7/16 and 6/16, both dated 7/9/2016, preferably within 3 months from the date of the said order. The Commissioner of Income Tax, Judicial, Kolkata, has issued a public notice dated 24th April 2023 for empanelment of senior and junior standing counsels. Thus, in the light of the directions issued by the Ministry of Law and Justice, the new panel of senior and junior standing counsel has to be drawn by the Income Tax Department, for which already process has commenced, and the last date of receipt of applications has been fixed as 12/5/2023 by 4 p.m. This court is concerned about as to how the matters the matters will be disposed of by this court in the intragnum. It has been made clear in the order of the Ministry of Law and Justice dated 19th April 2023 that the panel counsels of the Department of the Ministry of Law and Justice, who are presently conducting the cases, conducting the income tax litigations before this court, shall continue to attend the matters till a new panel of advocates is formed. It has been highlighted before us by the learned standing counsels for the department appearing in income tax matters that their period of engagement is for 3 years. And as of now, only 1 year has been completed and 2 more years are still subsisting. It is also submitted that all the existing panel counsels of the Ministry of Law and Justice will apply for empanelment pursuant to the notice dated 24th April 2023 issued by the Chief Commissioner of Income Tax, Judicial, Kolkata. However, they express a concern as regards the clearance of the pending bills and also the bills that may be raised in future. Therefore, they seek for appropriate, therefore they pray for appropriate directions that all matters which were dealt with by the existing panel counsels till 18th of April 2023 shall be settled by the Ministry of Law and Justice, Branch Secretariat, Kolkata, and clear instructions may be given by the Income Tax Department, by the Commissioner of Income Tax, Judicial, Kolkata, as regards as to how matters will be dealt with and filed before this court and conducted after 18th April 2023. In this regard, we direct the that what is his name? Assistant Government Advocate. No.
Additional government.
Additional government.
In this regard, the learned additional government pleader,
Government advocate,
Ministry of Law and Justice, as well as the Commissioner of Income Tax, Judicial, Kolkata, shall file a report before this court as to the modalities which will be adopted by both the departments. This will enable the court to issue appropriate directions so that the disposal of the cases before this court will be unhindered.
Well, at one more point. Well, at the appointment of the councils was by a presidential appointment. Well, whereas the CBDT circular, which was issued on the newspaper on 24th April, is contradictory. Well, once the panel is not expired, no authority can issue any circular unless otherwise.
You challenge the notice. List the matter on 12th May. Let a copy of this order be forwarded by the registry to the what is it? Additional Government Advocate so and so, Ministry of Branch Secretariat, and the Commissioner of Income Tax, Judicial, Kolkata.
Report
Next, in the previous matter also, senior counsel was there. Matter got resolved. So in this matter also, he is going to be there. We'll resolve.
Item number 6.
I'd like to appear on the app. I have served
88 days.
Yes, delay can be minor.
But today, 3 o'clock, Lordship has got another bench. Lordship. So today, delay will continue. We have heard Mr. Amit Sharma and Mr. J.P. Kaitan, so on so. There is a delay of 88 days in filing the appeal. The reasons given in the affidavit filed in support of the condoned delay petition are found to be satisfactory. Hence, delay is condoned. Hence, application is allowed. Delay in filing the appeal is condoned. Next.
I'm grateful.
Item number 7.
Lord, I'm appearing for the apparent Lord.
How many days?
1 to 18 days delay.
Penny stock.
Penny stock, Lord, yes.
Same order.
Penny stock.
Dismissed. Hey, this bundle. Previous one. Next.
Item number 8.
Lord, I'm appearing in this matter, Lord.
This also.
There's a delay of, my Lord, 1186 days, my Lord.
Same order dismissed. Subhash Agarwal for respondent.
Deeply obliged.
Next.
Item number 9.
Lord, I am appearing in this case, my Lord.
I have
No, there's a delay of 2 days, but delay may be condoned, but this is a
2 days only.
2 days, my Lord.
All right. Heard so and so, Mr. Ganguly, etc. Satisfied. Same order, sir.
I'm grateful, Lord.
Delay condoned.
Will it be on Monday?
No, Lord.
No, next week, Friday only.
Well, Friday is a holiday.
It will come on, sorry, in Thursday.
Yes.
It will come on 4th.
I'm grateful.
This bundle is. Please call. You call. AG is there. Call.
Item number 10. Public interest litigations.
My lord, I am appearing on behalf of the petitioner, but on behalf of the petitioner, but my learned advocate, Mr. Srikant, the advocate on record of the petitioner for item number 10, 11, 12, and 14. I am praying accommodation on his ground because he has left the court for his personal he has left the court today for his personal ground.
What is the matter?
I don't exactly, my lord. I'm
my
only
lord,
praying for accommodation and praying for not today, my lord.
My lord, it's not adversarial at all, my lord. Here, my lord, what had happened, my lord, a request was made by the High Court and its administrative, my lord, jurisdiction, my lord, if I may use that expression, my lord, for my lord, video conferencing facilities and my lord, land, my lord, connection in 804 courts. Now, 804 courts, which we received, my lord, on my lord Monday. So, my lord, I put it through to my lord the judicial department, my lord, to my lord administratively approve it, and then my lord it has to go, my lord, for finance. So, my lord, because earlier, my lord, this proposal hadn't come. Whatever proposals had come, my lord, we had, my lord, carried them out. So, this is an additional, my lord, proposal which has come. So, it's just been routed for administrative approval.
We require some more orders also in this regard. Recently, Supreme Court has issued a direction 3 days back that all district court files have to be digitized.
Yes.
So it will be placed before the committee today. We will consider because it's going to be a high budget
Yes, my lord, our present Chief Justice, my lord, is on a war footing on this, and my lord, just as well. My lord, it, my lord, makes things so much easier as well.
We'll try and do something. So we'll adjourn it after vacation.
Yes, my lord.
We have heard so and so, so and so. The learned Advocate General appearing for the state submitted that very recently a proposal has been
This
received.
was a synopsis of the report already made over. My learned senior friend had requested me to make over a synopsis. There was a delay on my part in making
All
it
right.
over. But
It
that
is
was a
submi- learned-
synopsis.
It is submitted by the Learned Advocate General. A synopsis of the report filed on behalf of the High Court has been handed over, and he requests some time to analyze the said report and seek for and also seek for necessary administrative approval from the Judicial Department, and thereafter for the government to take up the matter. With this submission, with this submission, adjournment is sought for. Let the matter appear on 9th June.
My lord, kindly make it the week after, my lord, 16th.
16th June.
Obliged, your lord.
This will be item number 10, 11.
Only 10. This is only 10.
Only 10. Then what is 11, 12,
My lord,
13?
11 relates to, my lord, the vending zones. And my lord, licenses being given, my lord, to my lord, hawkers, my lord, to operate in vending zones. My lord, all reports have been filed. It was put down, my lord, for final hearing. So, my lord, if my lord, the petitioner is in difficulty today, my lord, kindly, my lord, keep it
So
on.
11, 12, 13, 14.
11, 12 and 14. 10, 11, 12 and 14.
No, but
Not
vending
13.
zone, vending zone, my lord, is the next matter.
11.
Yes, 11.
12 is different.
No, but 12 is a different matter.
12 is a different
Item
matter.
11, at the request of the learned advocate for the appellant, give some date in July. Then what about 12?
My lord, 12 also, my lord, is a relates to, my lord, the
Well, 12.
Clinical Establishments Act.
12, if I can just say. This was a matter where public interest litigation was,
Oh, okay.
a public interest litigation was filed for switching a system of private hospitals to be completely controlled by the state by entire price fixation. Now, none of the private hospitals were made as a party. So I made an applications. After hearing me, the Honorable Division Bench added me as I'm one of the super specialty hospitals as a party. Thereafter, I pointed out that the identical point was taken up by the Bombay High Court, the Division Bench, wherein the Honorable Division Bench of the Bombay High Court ultimately found that constitutionally, the state of Maharashtra lacks jurisdiction to do the price fixations for the private hospitals in non-COVID matters. For COVID, because of the Supreme Court directions, it is permissible. Now that matter was challenged before the Honorable Supreme Court, dismissed the SLP. After taking note of that, the Honorable Division Bench wanted to know the stand of the state. Because then the state took a stand because of this settled position of law, possibly we cannot make a legislation on that. Well, we have given our detailed affidavits, and we have also said that the litigant has suppressed a fundamental rule. Well, there are hierarchy, the legislations, the rule, and the regulation made by the creature of the statute. Under the rule, entire power has been given to the private hospitals to fix their tariff. It's the question is, are we doing it transparently or not? Not a question is that every mechanism of tariffs to go entirely to the state. So the last occasion direction was that state is to give an affidavit to express their stand. So this is, my lord, just the nutshell.
Now, my lord, may I tell your lordship, my lord, this particular writ petition seeks, my lord, directions against, my lord, the commission, my lord, to frame, my lord, certain regulations. Now, my lord, it has got nothing to do with a challenge. The challenge has already been filed, my lord, in separate proceedings. So as far as this writ is concerned, my lord, with regard to the reliefs which have been claimed, my lord, I would stand up and submit before your lordships, my lord, there cannot be a mandamus directing a regulation to be framed. So this writ should, my lord, go. With regard to whether, my lord, there is, my lord, legislative competence to, my lord, have, my lord, these kind of regulations or a provision to that effect, my lord, that, my lord, is a subject matter of a separate writ which your lordships can
Which
decide.
is that writ petition?
My lord, I don't have the number. My learned friend, my lord,
I'm giving, I'm giving.
Anjal, give item 12.
and item 12, my lord, my learned
Order
friend,
sheet.
my lord, naturally, my lord, the
But
petition.
I completely agree with this, the law point that seeking a mandamus for a legislation, my lord, that may not be permissible. I agree with learned.
Because, my lord, the provision is, my lord, the commission is authorized to frame a regulation in consultation with the government. But, my lord, to direct, my lord, the commission to frame that regulation, my lord, I don't think a mandamus, my lord, can be granted. And there's, your lordships are aware of the cases, my lord, I don't think. But the petitioner
Well,
here
in
is
fact-
asking for time.
In fact, my lord, I brought a very latest judgment on the identical point in
But the
2000.
prayer is
Yes,
mandamus to direct the respondents 2 and 3. 2 is the state of West Bengal Clinical Establishment Regulatory Commission. 3rd is chairperson of the Bengal Clinical Establishment Regulatory. To comply with the provisions of 38(1), 1I, 2I, 4I.
which is, my lord, to frame a regulation.
Oh.
My lord, 38, my lord, gives the power to frame regulations. Your
And my
lordships-
lord, he doesn't say about the rule which is under
No,
19.
that's also suppression.
Yes,
above.
there is a cross suppression.
My lord, that is, my lord, with regard to whether, my lord, the validity of the provision, that's subject matter of, my lord, another, my lord, writ. Here they seek implementation of, my lord, section 38.
Ready, 19 ready. Good, good. Lordship, may I have a look at the rule 19(1), which
No, we are seeing what orders were passed earlier.
Yes, my lord,
Lordship may see the order on
26 August.
the first 26th of August 22.
That's what we have got.
There, my lord, the Honorable Division Bench took note of the.
He submits the applicants of file
Yes,
WPA 4356 of challenging the constitutional validity.
yes.
123.
that's the other matter, my
Lordship may
lord.
also see the order dated 13th of January.
That's 4356, my lord. That's the matter, my lord, which deals with,
Which is different.
yes, which,
Judgment ready. No, hospital association.
But this ground appears to have not been canvassed earlier regarding maintainability of the.
no, my lord, I'm a late entrant
At
in this
this
matter
point, for
also.
the first time after, because I am the ultimate person who would be affected.
All right, but he is not ready.
Yes, my lord, yeah, I have no problem, my lord, because this needs to be argued.
All right, at the request of the learned counsel for the petitioner. July. Next.
Item number 13.
What is 13?
And I am appealing for the petitioner, my lord. We have served the exception of the report filed by the respondent number 7.
What is the matter?
My lord, this is a PIL matter, my lord. We have challenged the unauthorized construction of 4 premises, my lord. Respondent number 17 has filed a report, my lord. And we are supposed to file our exception, my lord.
And we have filed a report. I am for the Kolkata Municipal Corporation, my lord.
They have alleged in this writ
You are
petition.
appearing for?
I am for the respondent number 12 and 4. Respondent number 4 was the officiating that particular department, which is the Khashmahal department of Kolkata. And they have alleged in the public interest litigation that these are the 4 plots where this government authority is the owner. These are the Khashmahal lands, which is khash to the government. And these 4 persons are making unauthorized construction on these 4 plots. And my lord, in our affidavit, my lord, we have stated
that which are the plots we have issued the lease in favor of which persons. We have stated all those things, and against whom the lease was cancelled because of the non-compliance of the terms and conditions appended in the lease deed.
All right, he has filed some exception to the report.
My lord, my clerk has missed that exception. My lord, I am praying for my lord 1 day accommodation to file our exception.
That you don't have the copy.
And I don't have.
You have to file it, no?
Yes.
But
But we
you
have
so-
served, my lord. Exception.
All right.
I have
Time adjournment. My property has been unnecessarily included in the hotspot and I have been injuncted absolutely. All the reports is in my favor. No construction in my land, but subsequently I have been added in the proceedings and I have been stuck.
Then
And every
let-
time
you
adjournment,
file your
adjournment.
report.
My lord, well, I am the petitioner.
No, you have filed some exception. You have
Yes,
given
my
us
lord,
that-
exception to the report
That copy is not available with him.
with,
You are instructing junior.
my lord, we've served, my lord, kindly.
You won't give us copies?
No.
At the request of the learned counsel of the petitioner.
Kindly,
Time is granted
kindly
for-
record, my lord, that this is the last adjournment.
Time is granted for filing the exception to the.
Every time it is adjourned.
Every
time.
Next week. Next week. Item 14.
Item number 14.
What is item 14, sir?
14, I am for the petitioner. I am praying for accommodation on the ground of petition, learned advocate, Mr. Advocate on record, Mr. Srikant. He has urgently has left the court for his personal ground today, my lord.
All right, at the request of the learned advocate for the July. Next.
Item number 15 and 16.
Ravi for the
Item
state.
number 15, we beg to appear with the state respondents, my lord. We have filed, my lord, our compliance report.
What is the matter?
Matter pertains to, my lord, illegal construction.
And what have you done?
My lord,
You issued notices, that's all.
No.
my lord, the order passed by this honorable court has been carried out, my lord. We have rendered adequate police help to demolish the illegal construction. And in the meantime, my lord, Supreme Court has stayed the order. And
last occasion.
Have you implemented yourself in the Supreme Court?
Yes, my lord, for the petitioner, the next date of hearing is 4th of May.
So therefore, let the Supreme Court deal with the matter. So by this public interest litigation. By this public interest litigation, direction was sought for on the respondents to take steps to demolish the unauthorized construction at the premises in question. Certain interim directions were granted by the, in these proceedings, direction has been granted, which has been challenged before the Hon'ble Supreme Court. And an order of interim stay has been granted and the appeal is pending. In such circumstances, the writ petition is closed and with liberty to the writ petitioner to agitate the matter.
Lord, after certification.
If so advised, after the disposal of the special event.
You know, after certification.
WPO. It's a public interest litigation. No, this is a what is the single bench order which is filed here?
Page 21.
Page 21.
21. Yeah.
This is the report. Twenty-one. Oh, there was a cluster of.
There are 4 premises, buildings, my lord.
And as against this order, any appeal has been preferred.
Appeal has been preferred before the Supreme Court, Honorable Supreme Court.
all the property.
Not against all the properties. My learned friend will enlighten. Which property, in respect of which property appeal has been preferred?
3 by 5 by
3/1 Narkeldanga Main.
3 by 5F Narkeldanga Main Road.
That
3 by 5 first one.
There was a cluster of.
But in the order of the Honorable Supreme Court, it states, my lord, 3 by 1 Narkeldanga Main Road.
we submitted that the order directing
But
demolition.
there is no 3 by 1 or 3 by M.
of the premises has been stayed by the Honorable Supreme Court.
Order.
Let the matter go out of the list with liberty to the learned advocate to mention for inclusion of the matter after the disposal of the special petition. Next.
Item number 17.
Second.
I am for the petition, my lord.
Lord, I beg to appeal for the respondent number
This is the affidavit
4
of
and 5,
service.
Lord.
Lord, in
I'm for
this
the Union of India.
subject matter is the under Right to Information Act. There is a circular issued by the Ministry of Panchayat and Rural Development. Thereby the first appellate authority has been appointed by a Panchayat Pradhan. He is a political person. That is my first subject matter of challenge. Political person cannot be the appellate authority.
All right, we'll take up your matter next week
Oh, yes.
because there is another division bench at 3:50.
Not
Let it remain in the list.
But state's representation is required, Lordship.
Monday.
I have served duly, all not served, duly served.
Monday it will be called.
The affidavit of service kept with the record.
Affidavit service taken on record.
But state's representation is required since he has challenged state of government of West Bengal on notification.
You
If you
please-
Kindly indicate the concerned department is already added.
Very good.
Panchayat and Rural Development.
Grateful, Lordship. এই যে affidavit of service kept in record.